judgment WPC 4200/19 Amila Khatun versus Union of India.
Okay.
For delivery of judgment, item 2, WPC 5607/19, Benubala Singha versus Union of India.
Both was for grandfather and grandmother. They was not with the father of the petition. They did not come together. And so that the linkage is not good. Plus the revenue receipt they have given, but then there was a big gap in between. And then the author also was not examined as far as the governance is concerned. Right? On this not still.
14 may be Passover for, and 14 may be Passover for, and time may be given for 2 weeks. I have taken the consent of the other party.
Which is a representative of the affair may time subject to ask for the consent to the petition. Sorry, respondent. This after?
We get us
After
after 2 weeks.
2 weeks.
You may pay a logic. The similar prayer with item number 11, one, it's a matrimonial dispute, madam, husband and wife. I've taken the consent of the other side, madam. So it may, after 4 weeks, madam.
But this is 2024 matters pending for.
Actually, madam, it's a divorce petition for transfer of a divorce petition, madam, between the husband and wife, madam. And the engaged counsel of the petitioner side, she is in Gauhati, madam. She has informed me, madam.
So the problem is that somebody has filed an application for transfer of a matrimonial dispute.
Yes, madam.
It is pending here for 2 years.
Yes, madam. But we are trying for an amicable way, madam.
That does not serve the interest of anyone, and both sides suffer.
Lordship.
If a matrimonial dispute is kept pending for in court storage for too long, take a short date. How much?
Any date, Lord, but she is in Gauhati, madam. The counsel for the, she has informed me, madam.
Oh, yes, you see, they are making demand for a high court bench there. They can join us in video conferencing.
Yes, yes. No, madam, she practices here, but she went to Gauhati. Not in the speak after 2 weeks, madam.
No, not 2 weeks. Make it after a week. You can join by video conferencing. Item 7, both sides are presented. Last time after the 11th, the respondent is for 4 weeks' time. Next one is a transfer petition and pending for 2 years. From a long adjournment is refused. It will be any learned counsel having difficulty to appear in person, may join the video conferencing on the next date of listing. Next file is coming, date next week.
21.
Obliged, madam.
May I please, Your Lordship? My lord, I beg to mention for a listing of a miscase for restoration of a second appeal, my lord.
All place for listing, please
My
give
lord,
to the
there are some
court.
urgency is there tomorrow, my lord, because the execution is being pending there in my lord. Tomorrow, my lord.
Obliged, madam.
May I please, Your Lordship? Lordship, may kindly allow me to peruse the case record in respect of item number 26.
May I please, I recommend item number 18, lordship. And agenda matter for today, lordship. And listen matter after by lordship. 18.
18, this after a week has paid for by local counsel for the appellant.
Wait, please, Your Lordship. You beg to mention item number 6 of today's list, madam. This matter may be adjourned for 2 weeks, madam.
List after 2 weeks is paid for by local counsel for the petitioner.
Please, Your Lordship.
May I please, Your Lordship? With the consent of the other side, Lordship, beg to mention item number 16, Lordship. Lordship, the matter will be passed over for the day, Lordship. Lordship, there is an interim order, Lordship, that may continue, Lordship.
You are for,
I'm A Mena, Lordship.
we are appearing for whom?
Lordship, for F1, Lordship.
Lordship, that may be 6 weeks.
You are appearing for the petitioner.
Yes, Lordship. I'm for the respondent, Lordship.
Both sides are represented and clear for parcel for the days made by the counsel for the petitioner. List on 15/5/2026.
The interim order is,
Interim order passed release stands extended till. Yeah.
the date may be fixed.
You fix a date, you don't hear.
P1.
May I please, Your Lordship? Lordship, I beg to mention item number 13, Your Lordship, on behalf of my senior B and government. After taking consent from the other party, Your Lordship, Mera matter kindly pass over for the timing, may be taken up after 2.
Okay.
Lordship, I beg to mention item number 29. Lordship, with consent from the other side, let the matter be fixed after a week, Your Lordship.
Lordship, I'm for the petition, Lordship.
You're for the petitioner.
She is for the petition. I am for the respondent.
Why you are seeking time?
Lordship, we have just filed our objection.
If you find your objection, we'll look into it. It's a
If we don't, it's not yet tagged with the matter, Lordship. We just want it to be tagged with the matter.
This problem, both sides are represented on the prayer made by land counsel for the respondent. That the affidavit filed by the respondent be tagged with the record. List on 18/5/2026.
Lordship, there's the interim, Lordship, maybe continue for the next, till the next, there is the interim, Lordship.
Okay, interim order passed release stands extended till the next date of listing.
Give approval.
Obliged.
Daily list, item 1 for motion.
Please, Lordship. Lordship, this matter may pass over for the timing.
For the time being,
Timing.
Item 2.
May I please, Your Lordship? My lord, petitioner is, my lord, the wife of respondent, my lord, sole respondent. She is paying for transfer of a, my lord, the matrimonial proceeding, divorce, my lord, from Gauhati to Hailakandi, my lord. Here, my lord, they were married in the year 2015 at Hailakandi, my lord. And for few months, my lord, they stayed at Gauhati. And subsequently, my lord, in the year, my lord, 2018, in the meantime, my lord, they are also blessed with a male child. And subsequently, in the year 2018, he got a job, my lord, at Hailakandi Civil Hospital on contractual basis. Accordingly, they were mutually, my lord, so long staying at Hailakandi, my lord, at her paternal home, my lord, and with full cooperation with the, my lord, husband, my lord, respondent here, my lord. And subsequently, my lord, suddenly he filed, my lord, this divorce suit before the family court, Gauhati, my lord. And she is still working at Hailakandi, my lord, staying with her parents, my lord, and school-going children, my lord. I have also submitted his recent admission receipt, my lord, page 18. He is reading, my lord, Rabindra Bharati High School, my lord. And in her application, my lord, page 13, this is admitted also, my lord, this aspect, my lord, she is working at Hailakandi, my lord. Paragraph 3, page 13, my lord.
Okay, but Mr. A.M. Bornia, then counsel for the petitioner. Therefore, the petitioner is the estranged wife of the respondent, and by filing this application under section 24 of the CPC, 6 transfer of proceedings of FC within bracket civil, this case number 1636 of the 2025, from the Court of Principal Judge, Family Court, Roman 2, Harbour Metro, Gauhati, to the Court of Lanad District Judge, Hailakandi. Issue notice returnable on since we did after 4 weeks. Petitioner shall take steps within 2 days for service of notice on the respondent by the speed post PDD. Next one, as an interim measure until the next returnable date for the proceedings of FC civil case number 1636 of the 2025, pending in the Court of Council, shall remain state. Next one, the petitioner shall produce a certified copy of the order to before the learned Principal Judge, Family Court, of Metro Gauhati, bring the order to the notice of the learned court. Next one,
15th June.
Diploma.
Item 3 for motion.
May I please your lordship? Actually, this is a petition filed under section 24 for transfer of the proceedings of divorce from the Honorable Court of Huzai Sankodev Nagar to the Honorable Court of District and Sessions as my lordship Jati Road. My lordship, the Morika, my lordship. My lordship, there are marriage was solemnized on 6/10/2011, my lordship. A social marriage at Huzai, my lordship, and the child was born on 17/9/2017. After that, my lordship, during her stay in her matrimonial house, my lordship, she was subjected to torture of physical and mental. Thereafter, my lordship, on last, my lordship, on 13/6/2025, she has lodged an FIR before the officer in charge of the Jagirod police station, which was transferred to the registered before the Huzai police station, and it is registered as Huzai PS case number 241 of 2025. After the lodging of this FIR on 13/6/2025, my lordship, the respondent husband has filed a petition for decree of divorce, my lordship, on 11/9/2025, my lordship. My lordship, the respondent, the petitioner herein, my lordship, she is residing with her minor child at her parents' house, my lordship. Both the parents are elderly. The father is a retired employee, my lordship. And my lordship, see, from the last more than 6 months, my lordship, I have even enhanced the medical documents, my lordship, and that she is suffering from excessive menstrual bleeding because of menopause and mental pressure, my lordship. And moreover, my lordship, she has no person to accompany her also. She has an elder brother, my lordship, but he is residing separately because he does not want to get involved with those issues, my lordship. And my lordship, he, in the meantime, the respondent has also married another lady, my lordship, on 3/6/2025. While she only returned to her matrimonial, from her matrimonial house, my lordship, on 21/3/2025, my lordship.
Is the Gauhati and counsel for the petitioner? Petitioner is the estranged wife of the respondent. Has agreed for transfer of the proceedings, matrimonial proceedings of title suit within the divorce number 66 of 2025. Page 1, Mr. From the court of district judge, learned district judge Bujai, Shankardev Nagar, to the court of learned district judge Morigaon, where she is presently residing. To notice returnable on, make it same day, returnable on so and so. Petitioner shall take steps within 2 days for service of notice and be responded by speed post with AD. In the next date of listing, for the proceedings of PS within bracket D number so and so shall be state. The petitioners have produced certified copy of the order before the learned district judge Bujai Shankardev Nagar to bring the order to the notice of the said learned list on
15th of June.
Obliged, my lordship, I look.
Item 4.
May it please the court. My lord, an ex-parte decree was passed way back on 29/8/2023. My lord, we have challenged it by filing a miss case 17 of 2025 on 5/3/2025 under Order 9, Rule 13. My lord, I'd like to take your lordship through that application because that is a very important one. How, my lord, the statement made by us that was stated to be something that we did not say. So therefore, I would like to read that at page 75. Maybe. I'll read from paragraph 3 onwards, from 2 onwards, at page 77.
First of all, please tell us why did the ex-parte decree happen? You received the notice.
My lord, that is the question, my lord. No point of time we have received that. And they have used one paper that is uploaded one, Xerox copy, and that was taken to be, my lord, the gospel truth.
Which paragraph you want us to read?
Now, your lordship, I'll read from para 2 onwards, my lord, in order to say what we actually stated there. So the present petitioner's father states that they were never served with any summons, notice of the aforesaid manuscript number so and so, and as such never engaged any advocate to file any kind of petition, and as such the case proceeded ex parte. And the petitioner further begs to submit that they were not aware about the manuscript number so and so. Further, it came to their knowledge after the writ had been issued, and the officials of the court went to the shop in search of them to execute the writ. That after coming into knowledge about the writ and manuscript, the present petitioners engaged an advocate on 18/2/2025 to make inquiry about issuance of any writ in this name. And after inquiry, the concerned advocate informed about the manuscript filed against Pankaj Sanitation and himself by Sri Timber Products Private Limited for recovery of rupees so and so. Then para 5, petitioner further submits that the manuscript was filed with a malafide intention to derive undue gain, and the summons of the suit were never allowed to be served on the present petitioner, and as such, no acknowledgement card or report from the Jarikar is available on the record. Then, my lord, I will take your lordship to para 11, page 79. The petitioner states that they came to know about the suit only after the court staff went to their shop in search of the petitioner, and thereafter they engaged a lawyer on 18/2/2025. And a period of 4 days was consumed in obtaining the detailed information of the case filed with the opposite party and the decree obtained by him. After collecting full information on so and so, the same were communicated to the petitioner. And after obtaining his instruction, the counsel for the petitioner was consulted and his opinion was obtained. And thereafter, the petition for setting aside the ex-parte decree was prepared and sent for obtaining signature and swearing affidavit. So the petitioner submits that since neither the summons notice of the suit was served upon him, nor he had knowledge of the filing of the proceeding, the suit, the limitation for filing application for setting aside the decree begins from the date of knowledge of the decree, which may be treated as on 29/1/2025. Then, my lord, your lordship, kindly see at para 15. That is the language which was, my lord, interpreted against us. That the petitioner submit that there was no willful laches or negligence on the part of the petitioner, and the matter has proceeded ex parte due to some extraordinary circumstances, as the person looking the matter has got bedridden, so there is no negligence on the part of anyone, and considering the circumstances of the case, the ex parte order may be set aside. Now, this, my lord, the statement made by us, it was interpreted as if I was knowing about the ex parte decree, but this paragraph is required to be read along with, my lord, paragraph 3 and 4. Now, what we have stated, that we have engaged our lawyer on 18/2/2025.
Where is the finding?
Finding, yes. Finding, your lordship, I will take your lordship to page 26. No. My lord, I will take your lordship from para 23 onwards, which is at page 38. I'll read from para 23 at page 38, my lord. Effect of the appellant's own admission. Lordship got it.
No, but you see, what we have seen is from page 25,
My lord.
that your engaged counsel had appeared and took for time.
Right. No, those are the things, my lord. 3 occasions your lordship will find the someone has taken time on our behalf. There is no vakalatama given by us, no point of time we have engaged. Who is that person? And 3 occasions he took time. We never entrusted that person, my lord. Your lordship will find from the record there is no vakalatama even. Now, those are the things, my lord, taken into consideration, that as if that we have engaged someone on 3 occasions, after that he disappeared. Now, my case is that when I came to know from when office staff came to my shop premises, and then I came to know and we engaged a lawyer on 18/2/2025. And then in that context, he have said the person means the owner of the shop, he was not keeping well. And therefore, my lord, he could not file this application under Order 9 Rule 13 in time. Because we have filed it on 5/3, whereas we came to know much earlier than that. Now, that sort of environment was interpreted as if I was knowing that fact even right from the date the ex parte order was passed in 2023. My lord, both the court, even the trial court as well as the appellate court, came the same finding. Now, here is a case, your lordship, kindly see, I will be made a non-class, my lord. The suit has been made ineffective so far I am concerned. Without hearing order decree of 18 lakhs have been passed.
Is that finding by the appellate court?
Yes. My lord, it's a long one, my lord. I will not take your lordship to all that. I'll take your lordship to page 43, paragraph 37 onwards. And from para 37, I will read. In the present, as your lordship got that, it's para 37 at page 43.
Yes.
In the present matter, the case pleaded is that the person looking after the matter became ill, and the case therefore proceeded ex parte. There was no willful negligence on the part of the appellants. The learned trial court has considered this explanation in conjunction with the admitted fact that someone was looking after the case. The record of three earlier petition, Your Lordship kindly said those three earlier petition was
Yes, you are
taken,
reading at page 43.
43, yes, 43, para 37. The last two lines, my lord. Lordship got it.
Yes.
The present matter, the case pleaded is that the person looking after the matter became ill, and the case therefore proceeded ex parte. There is no willful negligence on the part of the appellants. The learned trial court has considered this explanation in conjunction with the admitted fact that someone was looking after the case. The record of three earlier petitions by counsel in 2022 and the available material regarding service through registered post. From these, the learned trial court concluded that the appellants had sufficient knowledge of the pleadings. The explanation did not constitute sufficient cause for the entire period of delay. The delay was attributable to want of due diligence rather than to circumstances beyond control. In appellate review, the question is not whether this court would, in the first instance, have taken a marginally more liberal way. The question is whether the trial court's view is so unreasonable or vitiated by misdirection that it warrants interference. On the materials and on the appellant's own pleadings, the following features emerge. Knowledge and entrustment are admitted. This is not a case of litigant who was totally unaware of the proceedings due solely to a failure of service or fraud. The core of the appellant's own case is that the case was entrusted to someone and then not followed up adequately when the person became ill. No dates, no particulars. The
Is
section
the order sheet of the trial court annexed here regarding service of summons or the personal service report? Is it annexed here?
That has been discussed by the
Page 20.
No, but is the document available here?
document. Huh? We do not have. Lord, that I'll have to produce to you. Lordship.
We need to get that because if we have to see, we'll have to
Right,
examine
very
from
good.
that stage.
Right.
If the notice is served,
My lord, I'll produce that.
how much time do you need?
1 week. For your lordship can fix it Friday, my lord, I'll try my best.
Friday.
Friday.
You can get a scanned copy also that.
My
You did not produce the certified copy. And do you have a copy? No.
Service report. I have that record, Melody. I have not got it today. I can also try to find out, Melody. Because I had the certified copy of the entire order. And Melody, that clearly discloses, Melody, that after the notice was served, Melody, the track report and the postal receipt was submitted before the court. And it was that track report showed that it was somewhere served on May, in the end of May, and the counsel who has filed the application, petition, seeking time to file wakalatnama is on the 6th of June. So he filed 3 applications, and the last application, my lord, the ground was that the person is ill, and therefore he could not execute the wakalatnama.
Well, that I'll, my lord, persuade your lordships by giving the necessary papers.
It's okay. But as written on senior counsel, accepted by Mr. Ezbekar and for the petitioners. And Mr. D. Kaushik, learned counsel, the response, deviator. Next, brother. Issue raised with the witness revision relates to prayer of the petitioners for setting aside the ex-parte decree. The court desires to look into the process service report and the relevant order of report by which, on the trial court by which service of the petitioners was accepted to be duly served. Next part. Omit both sides. Please. Even an uncertified copy of the relevant report. Next one is bit by both sides, based again on 15, 5 and 6.
But I'll,
My lord, some of the order sheet,
the copy, just rolled at that execution for these 2 days.
the next date is on 25 and
It's okay, just see that.
yes, I'll,
my lord, some of the order sheet I have next page 71 onwards, whether the lawsuit is requiring this.
If, no, I just need only that. Relevant record where the service is accepted.
All right, my lord, that's it. Published.
yes,
Item 5.
May I please, madam? My lord, I pray that this matter will be taken up after some time, madam. My seniors will appear, my revision like some other.
After some time would be in minutes, hours, days, we don't know. That is. Just tell it.
Yeah, I will inform you. We are very happy, after a long time, my lord, is in the roster.
I am always here.
Now, in the roster, my lord, we will well. Problem.
Item 7 for motion.
Yes.
Yes.
More people should be more. Insurance company.
Yes.
What's it here? I have come to challenge the order dated 31/2026 passed by the MSCT court and the lordship in the cooperative order in page number 49. What happened? Cooperative page number 40, Lord. 40.
Yes.
So what happened here? In this, the insurance company took 8 days, about 1.5 years, in respect of filing evidence on the petition.
But
So-
this is a point where we'll have to allow the insurance to lead evidence.
Yes,
Their investigator found out that the driver had not been holding a valid and effective driving license.
yes, Lord, that I'm coming. That will be a matter of time. The thing is that, Lord, you can see. So that has been taken at page number 40, Lordship, in middle kindly see. Upon going through the order sheet, it appears that OP number 2 filed WS so-and-so. Claimant has filed evidence of it so-and-so. PW1 of the claimant was duly cross-examined by the OP number 1 and 2 and discharged, and case was fixed. Evidence on opposite party number so-and-so date was filed. Thereafter, again, adjournment was sought for so-and-so. DW was not cross-examined as OP number 1 sought adjournment that they would file additional affidavit and affidavit to exhibit some more documents, and some was allowed, and cross-examination DW1 was reserved. On the next date, so-and-so additional affidavit of some documents was submitted, and on next date, so-and-so finally 3/6/2000 DW1 cross-examined, and case fixed for argument, submission of account of claimant. So 36/2000 ex-parte order was passed, and on 31/2026 they have not tried to set aside that order even also. And planning court below what has did, you can be page number 42. Genuinely found that on the death of husband, now at such stage of what is the filing petition that they would adduce evidence, there is also no specific reason why they had not filed evidence earlier. So completely procedural. And annexure 9, page number 20, page number 29, can you see? Proceed. They have not come with any application to set aside that order. So that in the application, they have not mentioned anything. To set aside that order, limited settlement court has allowed with procedure that they would come up. And Lordship, this is a case of 2019. Can you see? 2019 investigator has not come. One day suddenly the investigator 31 has come up and said that the license is not valid. And even the license is valid on that period, particular time was not effective. So how such petition can be? Lordship, as order even to that aspect, Lordship, they cannot come before the court of its own. 2 years, LC. And even in petition, I have enclosed that petition is page number 35, Lordship. And see that petition, because in court itself says that there is no sufficient cause was shown. So how they can take part in the proceeding by filing any petition? If that is so, the procedure will go in that manner. And if they any time at any stage they will come up. Evidence 8 dates, 2 years. Then argument 4 dates have over. Almost 2 years, 2023 to 2026. They have come up before the court. Suddenly, on very same day, petition was allowed. And court has reflected there is no sufficient ground anything. And this is a new case. This is 2019, everything was done. Ample opportunity was come up. But nobody has come. So how? Our court's order in that aspect also.
You see, you are the claimant.
No, I am the opposite party, I mean, owner and driver. Owner come driver.
Then at your place will not interfere.
But in
Had
such
it
type
been,
of
had it
petition,
been, had it been petitioner,
no, whatever it is, I am ready to protect us. Can we see, something, first thing is important, without setting aside the ex-parte order, how the petition of further order court can pass such order?
validate that. This court will validate that.
Where is the sufficient cause has come up? So insurance company any day, any time will come up before the court.
Yes, yes. If it is the owner who's not having a driver with a valid license.
I have that driving license, I have the driving license, where he said that part?
See, if there is a delay, you don't suffer anything. Even if it is 2019 or let it be 2009 claim petition, as a owner of the vehicle, you don't suffer anything.
I'm challenging that I'm ready to part, but in respect of the procedure, how they have come up before the court, if that is the part, I have nothing to say, then it's okay. Then you can pass any order. If that is so, that taking so much time, they can come up before the court. Procedural is because they have to follow CPC. For them the matter was delayed.
Mr. Sharma, you can't take advantage of your own wrong.
No.
We invoke that principle.
No, one thing is to be admitted. I here say that thus they have to file a petition for first setting aside with limitation. If court would have allowed that part, I have nothing to say to that extent. But here what happened, court has not set aside its own order, they have not prayed to that order, the 30th page annexure 9, 2025 order which was passed. Suddenly under that 31, they have come up before the Honorable Court and file a petition they want to adduce because when in 2019 matter, you have never come up before this investigator has duty bound to, because the record statement is already filed there.
The delay.
That is what,
It is only the claimant who suffers, not you.
So claimant part is, I am paying that part. Insurance will have to pay. I have paid my part, so that will be reimbursed, and that is question of letter of time. Here what happened, my only submission, first, if they would have set aside that and prayed to set aside genuinely as per the procedure, without setting aside how the landed court can take success view.
We'll take care of that. But Mr. B. Sharma, the counsel for the petitioner. The petitioner is the owner cum driver of vehicle bearing registration number ES01 PF 6364. Which of the next vehicle is involved in a road traffic accident which had occurred this is the claim petition. What is the date of accident?
The date of accident, that is 2019. 7/8/2018. 7/8/2018.
2018.
Yes, yes. MHC, it is dated. That's this one.
Leading to death of the rider of a motorcycle bearing registration number AS01R1247. What is the average transfer? 8/8/2018. 8/8/2018. According to Thomas, the claimant who is the respondent number one claimant, who is the wife of the deceased, that filed a claim petition under section 166 of the MV Act of 1988, which was registered as MAC case number 361 of 2019, which is pending before the learned member of a Motor Accident Claims Tribunal from a Kampro Metro from Gauhati. The learned counsel for the petitioner has submitted that the respondent number two, which is the insurer of the said vehicle, did not need any evidence and sought for adjournment on 21/11/2023, 4/3/2024, and 14/6/2024. No, sorry, 14/6/2024 on 2024. And despite dates being fixed on 10/9/2024, 30/10/2024, 4/2/2025, and 30/4/2025, the learned tribunal by its order dated 3/6/2025 held that as the respondent to insurer was absent without steps, or the case would proceed ex-parte against the insurer, and the case was fixed for argument on 14/7/2025. Next, the respondent number two did not advance any argument after after 14/7/2025, on dates which were fixed on 10/9/2025, 15/10/2025, 15/11/2025, 6/12/2025, and on 3/01/2026, the respondent to file petition number 386/26 before the learned tribunal to allow them to adduce the defense evidence. The learned counsel for the petitioner has submitted that there was no prayer made for setting aside the order dated 3/6/2025 to proceed ex parte against the respondent of two. The learned tribunal allowed the said petition number 386/26 on the same date, i.e., 3/01/2026. Next, according to the petitioner, has filed petition number 900/26 dated 16/2/2026 under section 151 CPC, bringing for recall of the order dated 30 January 2026. However, the said application was dismissed and the case was fixed for cross-examination of BW2 as the learned tribunal had permitted the respondent to produce its witness even before or even before adjudication of the said petition number 900/2026. Accordingly, on the ground that the procedure adopted by the learned tribunal was perverse and not in accordance with the established procedure of the case. And that without recall of the ex parte order, the respondent two was allowed to adduce evidence during the pendency of the petition number 900 of the 26. The petitioner is saying the impugned order dated 30 January 2026 7/3/2026 asked in connection with MSC case number 361 of 2019. Next. The learned counsel for the petitioner has forcefully submitted that as the order of proceeding ex parte against the respondent who was not set aside, the tribunal would not have jurisdiction to allow the prayer made by the respondent to produce evidence. not accepted, so it is further submitted that. Although a lot of adjournments were taken by the respondent two and ultimately failed to appear and contest the proceedings. If the impugn orders are not satisfied, Council will lay down a new procedural practice which would permit anyone to make default in appearance and then get the ex-parte orders negated without assigning any good cause. Next one. In this case, the petitioner is the owner of the offending vehicle. And therefore, even if the proceedings of the tribunal is of the year 2019, the petitioner would not be the person affected by the delay in adjudication of the said MSC case number 36 of 2019. Next one. On the documents appended to this revision application, it emerges that the investigators of the respondent two found out that at the time of the accident, the driver of the offending vehicle was not holding any valid and effective driving license. Of which is projected to be a breach of the policy conditions. And therefore, the petition was filed on the ground that while passing the final award, liberty be granted to the respondent two to recover the awarded amount from the owner from driver of the offending vehicle. Next one. In the considered opinion of the court, as it is the projected case of the respondent number two that the owner and driver of the offending vehicle, i.e. the petitioner, was not holding any valid and effective driving license. Even at a related stage after taking adjournments, it would be within the power of the Motor Accident Claims Tribunal to consider the prayer of the insurer to allow them to produce evidence. This is because there's a mandate under the Motor Vehicles Act from 1988. What is the Motor Vehicles Act now? Motor Vehicles Act is year, which year?
Yes,
No, what is the year? I forgot.
so 1988,
What is the year of the act?
2019, which one?
The act is which year? Motor Vehicles Act?
Motor Vehicle Act in 1988, and this is amendment to 9/8/2019.
1988. I forgot the year.
Yes, oh.
1988. There's an amendment in the Motor Vehicles of 1988 for the driver of the vehicle to have a valid license, and therefore the driving of a motor vehicle without a license is a breach of the legal duty cast under the said Motor Vehicles Act, 1988. Accordingly, the court is of the considered opinion that the procedural law is only a handmaid of justice, and in cases where the owner and driver of the vehicle does not possess a valid certificate, valid driving license, as in this case, it would be within the jurisdiction of the Tenant Motor Vehicles Tribunal to pass the interim order next as Mr. How, considering the facts and circumstances of the case, or the court is inclined to when the court is inclined to not interfere with the interim order, it is made clear that the interim orders dated 30 January 2026 and 7/3/2026 as passed by the London member from a motor accident claims tribunal number 2, Metro Gauhati, is passed under the unique facts of this case, the said case. The said order or the order passed in this application way would be restricted to the unique facts of this case and shall not be a precedent for any other case. Next one. Accordingly, the court is not inclined to interfere with the interim order in the instance of the owner driver of the vehicle, against whom the allegation is that he was not holding a valid license. Accordingly, the petition is dismissed. Nothing contained in this order can be construed as if there is any finding by this court on the validity of the driving license of the respondent or the petitioner, and therefore the Tenant tribunal shall decide the matter without being influenced by any observation made in this order.
Only once, in page number 42, what happened, court has imposed 2,000 upon to the claimant. At least that part, because for the term they delay, claimant should get more amount at least. I have no new objection to that part. Because procedural, I'm challenging only, nothing else. The parties are ready to do that part. I have not come up with it. Because at least
for review of the order.
No, that's only that order, that compliance, that has not been proved. I have not included the complaint picture, anything before that. I'm not challenging that part. The thing is that they are also bound. They are appearing, they cannot take its own, come up in any case and delay the matter.
We have not made this order
Yes.
precedent.
Yes, Lordship. That
You
is
take your-
necessary
you take
because
document.
I have also the Supreme Court, their judgment in respect of the
Every-
same without,
Mr.
court
Sharma,
cannot bypass.
Every good thing must come to an end.
Yes, Lordship.
After we dictated the order.
No, because without court cannot bypass its own order. That is the Supreme Court decision and also our order also. That I am not placing all this.
We don't have a remedy, but you have a remedy available. Given that,
The thing is that because you come up with right way.
please don't continue the
Yes,
argument after
yes,
I have
obliged.
dictated the order.
All right. Complicated.
We are given that.
Yes, Lordship.
Or motion, time being item 1.
Lordship. So the trial court judgment against myself. Thereafter appeal has been preferred. Appeal also goes against me. So thereafter CRP has been preferred.
You are a tenant.
I am a tenant, your Lordship.
Yes.
So the case of the respondent was that I have defaulted in payment of rent since the month of September 2008. And having failed to pay the amount, he filed this suit for ejection as well as area rent.
2008.
2008.
Yes.
So prior to that, your Lordship, in the original claim, he claimed that I have defaulted in payment of rent since the month of August 2008. but that has been subsequently amended. Why, your lordship? He himself submitted a rent receipt counterfoil showing that I paid the amount up to August 2008. So when it has come to the notice, then it has been amended. And our case is that, your lordship, that up to the month of July, he issued the rent receipt, but thereafter he did not issue the rent receipt to me. So he again collected the rent up to the month of October 2010. And thereafter, when he refused to accept the rent in the month of November 2010, then I started to deposit the rent in court since the month of 2010, November 2010. And this is the defense of the petitioner defendant. There's another defense he has taken.
Just now.
Lordship.
September, October, you paid to him.
Yes, I paid October up to October 2010.
But he did not give rent receipt.
He did not grant rent receipt. Since the month of July 2008.
You deposited rent from November 2000.
November 2010 onwards, regularly.
Yes.
So there's another plea that was taken by the defendant that the advance amount paid to the plaintiff, about 20,800, is still with him. And that fact has been admitted by the plaintiff himself. And during cross-examination, he has admitted that that amount, advance amount, has not been deposited, they adjusted till today. So that fact is another factor. So we laid the evidence. During evidence, your lordship, the defendant side filed a petition to direct the plaintiff, the landlord, to submit the rent receipts, counterfoil as well as the books, to show that I have paid the amount up to month of September 2008. Because his claim is that as I have not paid the amount, he did not issue the rent receipt. But he did not exhibited that rent receipt. Rather, we have established by exhibiting the NJ cases since the month of November 2010 and onwards, up to 15, when the evidence was filed by the defendant's side, that has been exhibited. And after collecting the evidence, the learned trial court, lordship, that the trial court judgment is not annexed, it is with you.
Do you have with you any copy of the rent receipt?
Lordship, I have annexed it once, lordship. If the revision application annexer 4, your lordship, at page 44 with my revision application, that was submitted by the plaintiff himself. The photocopy was submitted. It is a vernacular form, your lordship.
43A.
Annexer for 44. it has been shown in the receipts that the rent for the month of August 2008 was received by him on 8/10/2008, therefore it has been cancelled. It was written as 10/9/2008. So our claim is that since the month of July, he did not issue the rent receipt. So that is why we called for that documents before the trial court, but he did not produce it. There was an irregularity in the issuing the rent receipts to establish this fact. But it was a photocopy. We called the original one from the book. It was not exhibited because I had no rent receipts. So the learned trial court, your lordship, held that I have defaulted in payment of rent.
There's a small issue here.
Lordship,
Before we begin to hear. See, in in the file of IA 822,
lordship,
there is a service report of usual process. And the process service report says that the respondent numbers 11 to 16 did not reside at the address given.
no, there was an expert effect that limitation petition was there, lordship.
No, that's okay, but the process service says that this
Lordship,
respondents do not.
the
stay at
paper
this-
publication was made.
But we'll have to find out whether this, if they don't reside at their address anymore.
Lordship,
What is the, in this plaint,
plain, we have given the address as mentioned in the plain, your lordship.
in the plaint that Prem Bhavan is not there, that is why we are asking, page 20.
Now the original plaintiff died. His son and daughters, who are the alleged respondent here, they are residing there.
No, that's why we are asking you.
Yes,
You see,
they are residing there.
see page 20, that Prem Bhavan address is not here. Neither it is there in page 20, nor in the affidavit at page 28 of the plaint.
Lordship,
How does this address of Prem Bhavan come in?
it is their address, that address was given by them in the plain.
In the plaint, we are telling you to see page 20. In the plaint that Prem Bhavan is not there.
Yes, yes. Prabhat Chandra Mahanta, son of so-and-so, Sankarpur.
How does this Prem Bhavan come from where? That's what we are wanting to know. It has come in your memo of appeal for the first time.
Yes, yes.
Where does the address come from?
There is in the plain, your lordship, page 20.
The Prem Bhavan is not there.
Sankarpur.
Shankarpur is there, we understand, but this Prem Bhavan is not there. Process service report said he does not reside there at Prem Bhavan.
So-
And at page 48,
Lordship.
it is to be calculated for Swift law.
Hmm.
In the respondent address, you give for the first time this Prem Bhavan.
Sankarpur, Dispur, Gauhati 6, your lordship. And resident of, or this next address was given after inquiry being made, your lordship. There is a Prem Bhavan. Bhavan name is there. Because they have contested the appeal, the respondent here, lordship, they have contested the appeal. Title appeal.
Contest of appeal is something else. But the process service reports say that it is not served because they don't reside there. That is what prompted us to look into it.
Lordship, then we have to take again steps to be taken.
No. Steps will only, will come when we issue notice here.
Yes. Because notice has already been issued, report has come, there the paper publication was made, accordingly the IA application section 5 was disposed of.
That's true, but Address must be, which is there in the plaint. Okay. You got the reason why.
Lordship.
Look at the plaint,
Yes, Lordship.
page 20.
Lordship.
The address of the, your address,
My address has been shown Prem Bhavan.
no, it is Pran, P-R-A-N.
Pran Bhavan.
But when you serve
Oh,
notice, you make it Prem, and you don't
Lordship,
miss out.
that means that the house which is the Prem Bhavan or Pran Bhavan.
No, no, that makes a lot of difference.
That building where the commercial place is, that is my shop is situated, it is belongs to the defendant, belongs to the plaintiff, and it is known as.
In a very lighter note, if you say the name Pran,
Yes.
we have a senior counsel here in Pran. There's a movie actor also Pran.
And Prem is also there.
Prem was there, but Prem advocate is not there.
Not there. But so far the Sankarpur is concerned, Your Lordship, so far the house is concerned, there is no such as a Prem Bhavan or Pran Bhavan. Sankarpur is there, Lordship, Gauhati 6 is there.
So, but why this address, why the change of address? Pran, Prem.
The typographical error is there, Lordship. Before the appellate court, that address is given as a Prem Bhavan. And in that address, they have appeared and contested the appeal. So for the memo, judgment, appellate court judgment is 48, Your Lordship. All residents of Prem Bhavan.
do one thing, we'll take it up day after tomorrow in the meantime of that building.
Yeah, I will,
Take a photograph and then produce that photograph
Lordship,
of that building.
that's it.
You have a printer there,
Yes,
printer establishment
yes,
there.
yes.
It will show that establishment of printer, that signboard and a building.
The pay more front,
No, whatever. we-
Lordship,
that,
Lordship,
The house where the landlord is staying,
Lordship.
whatever name, bring that
Push me the
photograph.
support, push me. Medical reason. Also, Lordship, my clients over is the medical reason, he is in Chennai.
Anybody can go in, because if there is an address and then you know their address is there,
Yeah.
the
So
establishment
his
is there.
persons can collect it.
Somebody can give it. to
Yes,
you.
yes,
Huh?
Lordship.
Yes. In order to, Mr. Albina, let's say, council assisted by Mr.
Yes,
That's
yes,
the thing, Lordship.
Council for the petition. Next, in order to set in the. We have to confirm that the address of the respondent is the same place where and has put in the first item, comma, the what is inclined to directly petitioner to produce a photograph of the building where his establishment situated along with the establishment should also disclose the outside facade of the entire building, outside facade, okay, CADE, entire building. Next one, list on 15. 5 and 26. Right.
Lordship.
You can take this back.
Lordship. Obliged.
Item 8 for motion.
May I please, Lord? My Lord, in a title suit, my Lord, issues were framed on 12/11/2025, my Lord. And therefore, my Lord, the petitioner ought to have submit the list of witness within 15 days. But he could have not, my Lord, due to health issue, my Lord. And therefore, in this regard, is file a petition, which I have annexed 3, is 14, but that was not considered. Case 16 is the impugn order.
Page
16, Annex 4.
what is the date on which issues were framed?
Issues was framed on, my Lord, 12/11/2025.
12/11/25.
Yes, my Lord.
And you filed your petition with page
And
10 on
Miller,
11/2/2026.
11 to 26,
What is the date fixed for
11 to 26.
11/2 was the date
Yes.
after this 12/11?
Yes, Madam. Page 14 is my petition.
Heard Mr. I repeat,
Yes, Madam.
learned counsel for the petitioner. Next part. Case of the petitioner is that the issues was framed or be settled on 12/11/2025, and the next date of the proceeding was fixed for steps before plaintiff hearing within bracket SBPH for short bracket close on 11/2/2026. However, as he was suffering from illness, on behalf of the petitioner, prayer for adjournment was made. It was refused by order, the order dated 11/2/2026. They were restraining the plaintiff, the petitioner plaintiff to file only his evidence. Accordingly, the order dated 11/2/2026 passed by the learned civil judge within bracket senior division, bracket number 2, number 2, Gauhati. As held in this application filed on Article 227 of the Constitution of India. Next, issue notice returnable on what is the next date before the tribunal and before the court? 34.
And the next date is 24/7/26.
What happened on 34, 30 April? What happened on
On 34/2026, we have submitted the petition and stating that we have approached the High Court against that order.
next date is on
24/7/26.
on 15/6/2026. Petitioner shall take steps in course of the day for service of notice on the respondents by speed post with AD. Next part. As an interim measure, next part, as it is submitted, that the next date of proceedings is of 24/7/2026. The prayer for interim relief shall be considered on the next date of listing. Next part. In the meantime, the learned counsel for the petitioner shall show a certified copy of, photocopy of the certified copy of the order to the learned counsel for the respondents. In the proceedings of suit number 622 of 2023, pending before the Court of Learned Judge in the Senior Division, that is number 2, County to Gauhati. Next one, list on same date. This one. No, it did. You take a certified copy and give a photocopy to the counsel for the defendants.
Yes, ma'am. Obliged.
It's actually, I think a short break in come.
It is a look. So in this revision, we have challenged order dated 16/2/2026 passed by the learned trial court, by which our petition under order 6 rule 16 was rejected, Lordship. What happened, Lordship, was that during the pendency of the case, while it was at the stage of cross-examination of the DWs, the defendant number 1 expired. Accordingly, his legal heirs were substituted, and they accordingly appeared before the learned trial court and filed a written statement. Although their predecessor had already filed, had contested by filing his written statement, Lordship. So against that written statement, we have filed an application under order 6 rule 16 for striking out the pleadings, Lordship. Because since he had already contested the suit, filing of an additional written statement was not necessary, Lordship. And by way of that written statement, they had raised certain new pleas and defenses which were not in the original written statement of their predecessor, Lordship.
But that is permissible.
It is permissible, Lordship, but in the event the substituted legal heirs had some independent or separate rights to that of their predecessor, then only they could have filed the written statement, Lordship. Here they have tried to introduce certain new pleas and defenses, Lordship, which were not originally in the pleading of their predecessor, Lordship. They do not have any separate or independent right because their predecessor had purchased the plot of land, which is a suit land, which is a subsequent sale deed, Lordship. We are the original owners of the land, but they have purchased the suit land from the legal heirs of the vendors, Lordship, of our vendors. So they do not have any separate or independent right. The only right they have is through their predecessor and who had already contested the suit, Lordship. So filing of this written statement will only lead to prejudice and will amounts to abuse of the process of the court. That is the reason by which we have filed the petition under order 6 rule 16, Lordship, for striking out the additional pleadings. And moreover, Lordship, the suit has been pending since 2014, Lordship, and it is at the.
Where is the amended? Where is the amended?
It is at page number, Lordship, 40, Lordship. They have not sought for any amendment, Lordship, nor they have sought for any leave. They have after appearance, they have filed this written statement, Lordship, without seeking leave of the learned trial court.
Leave is not required.
But Lordship, what is
Is any procedural law laid down that the in any judgment or anything that the defendant,
Lordship,
substitute defendant, before filing of the written statement has to take leave?
Then, Lordship, the fate of the original written statement will be nothing then, Lordship. Moreover, if this new written statement is taken into account,
Unless you tell us what is the variation,
Lordship,
how does it materially affect?
Lordship may kindly take up our petition, that is annexure 4 at page number 47. Lordship may come to page number 50.
Just from. Yes.
Lordship. At paragraph number 8 at page number 50, they have inserted this following line, Lordship. The Gauripur Town Committee, the sub-registered are necessary parties to the suit. At paragraph 9, we have written that the suit is barred under, they have inserted this paragraph, Lordship. The suit is barred under provision of Assam Land and Revenue Regulation, TP Act, and Specific Relief Act. These defenses were not taken in the original written statement by the petitioner, Lordship. And in paragraph number 12, Lordship, of the written statement, they have added a completely new paragraph, Lordship, which was totally missing in the original written statement. The paragraph 12 was only a simple denial of the plea of the plaintiffs. They have made specific denial in this paragraph, Lordship. Jivendranath Chakravarti did not sell 2 katha 12 and half lishas land by executing sale deed number so and so. Dated
Where is your plaint?
Lordship.
Where is your plaint?
Plaint is annexure 1, Lordship. Page number 12. Page number 19 is the original copy. Page number 12 is the type copy.
You would have been well advised to thank the respondent. You know why? You're not, you see, number one, all whatever amendments have been made is only clarificatory. It doesn't change the nature and character of the original pleading. It's just an explanatory note. An explanatory note can be amended at any point of time if it does not alter the plea of the defendant. That's one. Second is, in page 53, paragraph 22, the defendants, respondents are pointing out that since you are out of possession, you should have made a prayer for khas possession. Whereas your plaint is that you want not to be disturbed of your possession. If you are out of possession, then you will have to amend your plaint. They've given you this information, and you should have thanked them.
That is correct, Lordship. But the thing is that
If you are not in possession, then even your suit goes. You want to contest this?
yes, Lordship, but Lordship produces Order 22, Rule 4, Sub-Rule 2. It states that any person so made a party may make any defense appropriate to his character as legal representative of the deceased defendant. So,
Taken that defense?
Lordship, but their defense ought to have been on the basis of their written statement.
No. Even, you see, after I dictate the order, when it comes after transcription, sometimes I am also stunned that this is the language I have used, and therefore I change my language. There is grammatical mistake when I dictate the order, and I suddenly find out that it should have been more appropriately worded. I do that changes. See, if somebody comes as a legal representative and takes a plea, which is not inconsistent, the only orders are that he should not take an inconsistent plea. None of the plea taken in the amendments are inconsistent. The written statement already filed. The only addition they are now making at is para 22, where they say that the plaintiffs are out of position and ought to have got for khas position. Contest this, then you will be debarred from making that prayer every point of time. Take a call, come at 2 o'clock. Take over.
Lordship, can you take it on Monday, Lordship?
Monday. Okay. On the prayer made by Mr. B.S. Dekar, on the counsel for the petitioner, this on 15, sorry, it'll be 18/5/2026.
Supply item 49 for motion.
Lordship, the conducting counsel is appearing through BC.
Am I audible, Lordship?
Yes. Yes, please proceed.
Am I audible, Lordship?
Yes, please proceed. No, very good. Yes, please proceed. Not getting your voice.
Lordship, this case pertains to Lordship. Here I am aggrieved by the order. Which is enclosed here in page 8 of my plaint. I have filed, the order is passed by the learned civil judge, senior division number 3, and I am aggrieved by the order because I have challenged the maintainability of the plaint in the money suit as money suit. And Lordship, the matter herein is that the land was acquired under National Highway Act 1956, and the matter was settled. And after settlement of the matter, the case, the the claimant has already received the money. But due to the deaths of the claimant, they received it after a long span of time. So since they have received after a long span of time, they institute a money suit stating that under mental agony, they suffered mental agony because it took some time to get the money. But the case suffers from res judicata as it is maintainable. The case cannot be entertained once the matter is settled, and we have already released the money. So, but the civil judge has not taken us the plea, has not considered us our plea, and has rejected my petition, and stating that since the issues are not framed. But Lordship, here under Order 7, Rule 14, sorry, under Order 7, Rule 11, sorry, Lordship, under Order 7, Rule 11, the plaint can be rejected on the maintainability and disclosure of cause of actions. So, since the matter is already settled, Lordship, it cannot be taken into consideration that they are aggrieved by anything. So they are aggrieved by the order. So, Lordship, the case cannot be entertained at this point of time. So I am challenging the order, Lordship.
You're getting our voice? No. Okay.
For motion, time being item 5.
Wait till
Sorry, my lord, could not be present for the review. My lord, here, my lord, on the earlier occasion, my lord, the petitioner, my lord, he is a member of a society, my lord. On earlier occasion, he has filed a suit before the, my lord, court at the ruler. My lord, challenging the holding of the, my lord, AGF, and also declaration that same is illegal, etc. And along with that, my lord, one petition under order 39 was also filed. Trial court had rejected it. In appellate court, my lord, while setting aside the, my lord, order of the trial court, remanded the matter back to the, my lord, trial court, which and also granted, my lord, status quo order. That was challenged before this honorable court by the present respondent. And this honorable court, by order dated 16/10/2025, has set aside on the ground that the acknowledgement of the illegalities of laws, my lord, that was my lord, existed in the earlier, my lord, AGM, and he would, my lord, rectify, my lord, all the, my lord, the defects, and my lord, as per the rules and regulation, it will be done, my lord. That order, your lordship will find, my lord, at page 19.
the matter was referred for arbitration.
Matter is now,
That is the order.
now my contention, my lord, here would be, your lordship may kindly have a look to this, my lord, particular order, my lord, page 19. Lordship may come to page 22, it's page, my lord. See? It starts from 19, lordship may directly come to, my lord, paragraph 9, my lord, of page 22, my lord. The learned, may I read, please? The, my lord, clause, paragraph 9, the, my lord, clause has been referred. and the submission of the, my lord, the respondent is, my lord. Paragraph 10 onwards. Then paragraph 11, he however submits that in the meanwhile, the date of AGM which was mentioned in the original notice 21/9/25 has lapsed.
Yes.
He however submits that in the meanwhile, the date of AGM which was mentioned in the original notice, that is 21/9/25 has lapsed. He further submits that the extended date of holding of the meeting on 25/9/2025 has also lapsed. Therefore, this suit filed by the present respondent, wherein the only relief,
Where is the plain, can I see the plain?
page 23,
Plain,
plaint.
Page 27.
Page 27 is the present plaint, my lord. I reiterated the same thing at page 35 also.
Just some. Yes, you were at that, page
I was at page 23.
23.
23. Paragraph 22, he also submits that petitioner proposes to issue a fresh notice giving a fresh date of holding the AGM after complying with all statutory requirements as per regulation 15 of the rules and regulation of Sri Biswanath Nagari Dapriya Osodhana. Remanding. Also for the petitioner has also submitted the first appellate court has heard in granting the order of suspension. My lord, so it may skip, my lord. On this submission, my lord, the matter was, my lord, ultimately disposed of at page 26.
Yes.
This court, paragraph 21. This court therefore set aside the impugn order passed by the Court of the Learned Additional District Court, Dibrugarh, in the Miss Appeal number 2 of 2025, subject to condition that the petitioner may hold the AGM after complying with the provisions of rules and regulations Sri Biswanath Marwari Dattavya Ausadhalaya, issuing a fresh notice. But for a moment, this particular, the rules and regulation of the society is at page 88. That should may come to page 100.
You want to say that, since the High Court had directed the AGM to be held, the trial court could not have passed order for sending it for arbitration.
Lordship, my lord. Lordship. First,
Not sustainable.
well, firstly, my lord,
You see, the High Court was in session in this 432 of 2005. The High Court was in session of an injunction application, which is VJ case number 132 of 2025,
okay.
arising out of
Yes, my lord, that is another aspect, my lord. What I am, my lord, on, my lord, there they did not, my lord, object to the, my lord, jurisdiction, my lord.
men
They,
become wise.
they neither,
Men become wise with passage of time.
and this particular, my lord, second AGM is the, my lord, follow-up action what they have committed to this court that will, my lord, publish the, my lord, next notice as, my lord, mandated by the rules and regulations. So what they have already, my lord, forgone their right, my lord, in the earlier, my lord, my lord, the petition, my lord, they did not ask that, my lord. Not only that, my lord, in the objection to the, my lord, section 8 petition, I have also said that they themselves has filed a suit against one of the members. Now, when the matter was, it is not a separate as such. This has a, my lord, the connection with the earlier, my lord, round of litigation or the suit, my lord. The suit become infectious because, my lord, they have said that they will comply with the, my lord, statutory rules and regulation and then do it. Now that having not done, we have filed the suit. So therefore, the court ought to have seen whether this observation of the court has been followed or not. And that is my specific case in the plaint as well. Now, instead of, my lord, referring to any of those submissions, my lord, what I have made, my lord, only on the
That's
basis,
not the ground to challenge in the suit. Is the plaint is at
yes, 27, yes.
You've come to the here.
My lord, yes, my lord. That is the ultimate prayer, my lord. Achut may come to page 35, my lord. What my pleadings
Void
are,
ab
my lord.
initio. You said that the notice is void ab initio. You see, somebody, Mr.
You see the prayer, my lord.
No,
Prayer
you
A
see,
also.
I am proceeding on a premise that when somebody consents to something, he consents to the legality of the thing, not the illegality of the thing. So if he says that, okay, the AGM has to be held, then the AGM must be held in accordance with law. And here they say that the notice of the AGM was disobedience to the judgment and order of 16 so-and-so flagrant violation, and then they give all these things and make the prayer. And they say that the appointment of the election officer
auditor
is void, and then he says that the report is illegal. What you call the C report is illegal.
So therefore, my submission before the court below was that the relief sought for the remedy, my lord, is in RAM, my lord, not in personam. It is not my personal right alone. My lord, the following of the rules and regulation, it affects all the members, not only members, my lord, who deals with this particular society. If the AGM, my lord, elects the new body and it itself is a, my lord, bad in law, any dealing that does, my lord, would be, my lord, void. So it is in RAM, it is not in person. That was also my submission before the trial court.
So you want to say that if the election
There
is held,
there is no such dispute between me and the
trying to
society.
understand your submission.
That's it.
You want, is it that you want to convey that if the AGM is illegal, an illegal body be elected, if they do something illegal, then file a suit?
My lord,
Because if the election is not in accordance with law, why somebody can't challenge even if there is a action? You see, the High Court did not say you commit all the illegalities and commit the and do the election.
No, the notice itself is, from the notice of election itself is apparent that they have not followed the rules and regulations. Firstly, my lord, under the regulation, my lord, there is a need for appointment of the, my lord, auditor by the EGM or the AGM. Now, 3 reports they have given. The 3rd report is given by one Basant and company. He was never appointed by any EGM or AGM. Number one. Number
Your challenge,
my lord,
that you are the plaintiff.
I'm the plaintiff.
You are the plaintiff, you challenge that.
Yes.
And if the challenge is made, in that, even when there's an arbitration clause,
The arbitration, firstly, my lord, as I said, my lord, since the relief sought for is, my lord, in RAM, my lord. And secondly, since it is, my lord, in continuation of the earlier suit, rather, my lord. And as per this meeting has been held as per the direction of this honorable court, that they will hold it as per the rules and regulations. Now, notice of election has been issued, wherefrom it is appears flagrant violation of the, my lord, rules and regulations. So I have filed this
but
suit.
see, arbitration clause, will it be, according to you, would be applicable or not applicable?
My lord,
Will this dispute
in
be
this,
within the scope of
in this
arbitration
particular case, it will not be applicable, my lord, in this particular case. Because I want the defendant or the, my lord, respondent to follow the statutory rules, my lord. There is no dispute with me, any commercial or other civil in nature between me and the, my lord, the society.
where is the arbitration clause?
Page 112.
82.
Page 112. Clause 25.
So 112 is something else.
My lord, this is the particular clause I am taking, your lordship. My lord, the other is
112.
page. Page 112 is that arbitration clause. Otherwise, it starts, my lord, from page 87, 88, 87. There is no dispute, my lord. Rather, before this court, they have said, yes, there are some flaws that will clear and will accordingly will hold it. So you hold it. Now thereafter, they, my lord, directly issued this notice in violation of the, my lord, the undertaking or the, my lord, direction from this court. And what is to be adjudicated, whether, my lord, rules have been followed or not.
If there is an arbitration clause, it will be the arbitrator will decide whether the rules have been followed or not. There can't be a waiver of the arbitration clause.
Since, my lord, it's a non-observation of the, my lord, statutory provisions.
So we understand you want an adjudication
Yes.
before a forum, which is the civil court. And there is an arbitration clause which says that go to arbitrator.
No, my lord, there has to be the dispute first, my lord. There is no dispute, my lord. If they have terminated me or they have deprived me of something, then would have been a dispute, my lord. Something I urge, they deny.
You see, so far as I understand, subject to correction because I was out of touch for some time. Arbitration, when there is an arbitration clause, the law says that you will have to approach the court before filing of the first statement of defense. Now, unless you file a defense, the respondents file a defense, how would we know that whether there is a dispute or not? They say that there is an arbitration clause, whether there be a dispute or not. Please invoke the arbitration clause under section 8. Yes. And on section 8, we don't find anything which says that there must be an admission of dispute by the other side. If you raise a point which has to be adjudicated, how can there be an ouster of arbitration? That's the only question we are asking.
Exactly, my lord. That is correct, my lord. But then, my lord, the court has to apply its mind also while adjudicating, my lord, that section 8 petition, my lord.
No, we are not the adjudicating authority. Why
Gotcha.
should we apply a mind?
No, I mean, I'm talking about the trial court. Trial court, in fact, has
Same thing.
trial court,
Arbitration
in
now.
fact, has formulated, my lord, 3 points for adjudication of the petition.
Okay.
And second argument, my lord, is that the rule mandates, my lord, of submission of the original memorandum, my lord, or the arbitration, my lord, agreement. In my case, one of the ground is that, my lord, they have not submitted the original.
Yes.
Then page 135, your lordship will clearly see, my lord, 134 is the order of the trial court. Does the submission of both sides the following question arises for consideration whether a valid arbitration
Just a
agreement
moment.
exists?
Just a moment. This is something. In your objection, where is that ground taken? Non-production of the
Objection
consumer arbitration, that is at 114.
objection against their petition.
No. The objection is there, we have seen at page 114. Where is the ground taken that the original agreement has not been abused? It's not there.
So it was raised verbally. It is not mentioned in the petition. Then the call for the record also, my lord, and can be disposed of, my lord, at the admission stage. Because now already AGM has been held, they are functioning.
Okay, anything else? Anything else?
It's covered the trial court also, whether in fact, point number 2 has formulated whether the present dispute falls within its scope. At page 135. And as per the learned trial code, as because all disputes are mentioned, the language of the clause 25 is that all disputes shall be referred, so therefore everything has to be referred. Whether that decision is correct, my lord, that also, my lord.
Yes.
In the context what I have submitted, that this is in continuation of the earlier general meeting notice. That aspect has not been discussed at all. This objection I have raised in my objection to the section 8 petition, as well as the basic foundation in my plaint is also that it is a continuation of the earlier one. They have committed, they have not done it. And regarding this jurisdiction of the civil court, that was not urged before the in the earlier round, it was not urged. So legal right party can waive. It is not a fundamental right, it cannot be waived. So when it is has been waived,
There cannot be an estoppel against the statute.
Legal rights, my lord, I'm talking about the legal rights, estoppel against statute is, my
So
lord,
the statute gives a legal right.
legal rights. So,
It will be waived.
yes, my lord. Now, when that, my lord, right has been waived, it is not that unlike fundamental right, it cannot be waived. It can be waived. There are a number of, my lord, the decision of the apex court also, my lord, on that, my lord, that legal right can be waived, my lord. And once you waive it,
Where is that waiver?
they have not asked it, my lord.
I'll tell you, yesterday while shaving, I cut my cheeks. When it is said that there is a waiver and there, every time you shave, you have to cut your skin. No. The point is that earlier I waived, for some reason I waived. This time when this is a litigation, I don't waive. A waiver will be in the present, not in the past. Past
No,
action
this
taken.
is, that's what I'm saying. This is in continuation of the earlier AGM. It is not that earlier AGM was for a different year. This is,
Suit. You did not revive that earlier suit. To continue with that waiver, you have filed a fresh suit. In a fresh suit, is there a bar that the defense cannot be taken?
but the subject matter is the same for the, my lord, year, my lord, 2024-25.
Any authority that once you waive, it will be a waiver forever. Even in a subsequent suit and proceeding, that waiver will continue. There is no continuation of waiver. Separate suit will have to be dealt separately.
Okay.
Any authority on the point, because we like it. We are taking out some jurisdictions where these issues come up every time. Any authority which says that the waiver in the earlier proceeding will constitute a waiver in the second proceeding also.
No, there's no two separate proceeding as it's a continuation of the proceeding. What I'm trying to say, the earlier meeting was for the
One
2024-25.
One proceeding is gone.
Now comes and they say, my lord, without, my lord, raising any objection as to the jurisdiction of the trial court, they said, yes, there are some flaws, some violation were there, we will proceed.
Again, it's a new concept to me,
Yes, my lord.
that once there is a suit filed, it will be in continuation with the other suit or other earlier proceeding. It's something new to me. Please elaborate.
My lord, the earlier suit has, my lord, culminated with the order of this honorable court.
No, then perhaps you are incorrect. Cause of action is different. In your case, your cause of action is different. If you tag it, then I'll be happy.
Yes,
Just
my lord, that will come to
give a statement that the cause of action arose in the earlier suit. Just make that statement and I will be happy.
the earlier cause of, my lord, what I am saying, the earlier there was a notice, 21/9/2022. Perhaps,
Mr. Saikia, I'm a simple man. I've asked a question, give me a simple answer. Is any part of your cause of action arises from the earlier suit? Just tell me yes and the end of the matter. You would not even allow Mr. Datta to stand up.
my lord, the suit is, my lord, premised on the, my lord, order of this honorable court, my lord.
That is also a cause of action.
Lordship, my lord. And the earlier suit, my lord, comes here and then
Order of the court cannot be a cause of action.
it is a continuation, cause of action is
Your cause
continuing.
of action- Please give that statement. I'm happy to read that. Please find it out and show it to me. That the cause of action, any part is the earlier suit. Just show it to me. I'll be a happy person. Don't.
I said, my lord, this is a separate cause of action arising out of the, my lord, the order passed by this honorable court. Yes,
From that notice,
yes.
please.
Page 35. The present suit therefore has been filed with a fresh and distinct cause of action arising out of the defendant's subsequent publication dated so and so, whereby they have attempted to convene the AGM in continuation of the earlier restrained AGM proceeding
whatever is
without
earlier.
complying with the mandatory provisions of the rules and regulations.
You have shown us the
The
same.
society and violation of the conditional direction issued by this honorable court.
So, do you permit us to record your statement that the learned counsel, the senior counsel for the petitioner submits that the cause of action arose out of the previous litigation?
But, this is the statement what I am submitting.
Page,
Page 35, madam. It's a part of my suit. Page 35,
yes,
seventh line from bottom, madam. The present suit.
is a fresh and distinct cause of action arising out of defendant's subsequent publication of so and so, that they've attempted to convene the AGM in continuation of the earlier proceedings without
Page,
complying.
page 35, madam, seventh line from bottom, madam.
But yes, I'm reading 35.
The present suit therefore.
No, 35 here is that since the AGM did not take place. First word in that page 35 is
Right.
judgment and order.
Yes, yes.
It's okay, let's just simplify things. Here we don't find that the cause of action arose from the earlier proceeding. We just make a statement, we'll record it and then proceed with the matter.
There was some time, madam. Actually, there was some time.
At 2 o'clock then.
Well, not today, madam, some other day.
Otherwise, my lord, the entire exercise,
See, we have spent some time, so it's not for adjourning. We just wanted to record your statement. You were making a very categorical statement that the cause of action arose from the earlier proceeding. We just want to record it. We are taking your consent, although it's not required.
No, madam, it is a part of the plaint, what I am saying, you can record it.
It's not there, huh? Then that's okay.
It is a part of the plaint, madam. I am not saying anything, madam, new, madam.
Then it's okay. Yes, Mr. Datta.
absolutely it's unnecessary drag this matter because it's an academic exercise, my lord. The AGM meeting already held on 1st of March, my lord. They have came before the different forum, including this honorable court. There are, may say certain dates and events, my lord, which they have not pleaded hearing. This petitioner, my lord,
If it is not pleaded, then you'll have to bring it on record by way of an affidavit.
no, these are all admitted facts. I'm just pointed to this honorable court, just the background of this matter and this petitioner, my lord. This petitioner has filed a suit, title suit number 10425 first on 19/9/2025. The learned trial court refused to grant an injunction against the AGM.
You see, we have some difficulties. That's that's the point. You see, come to page 73.
30 minutes. Preservation is after the issuance of the notice.
Please come to page 73.
73 minutes. 72. Yes.
Cause of action arose on 3/2/2026 when the defendant published AGM notice fixing meeting on 1/3.
Correct.
So 1/3 is not a cause of action.
No, only the notice is the preservation.
Therefore, you are introducing something which is not there in the plain. So you'll have to file an affidavit if I have to rely on it.
My lord.
You'll have to do it because otherwise we will be passing orders without reading. Anywhere if that comes from the documents appended to the.
Otherwise, the issue before this honorable court, my lord, that's the impugned order, whereby the learned civil judge has referred the matter arbitration in pursuance of clause 25 of the memorandum, which, my lord, provided the internal mechanism of the dispute resolution. So therefore, and the learned trial court, my lord, elaborately discussed all the points raised by the parties, also relied upon the judgment of Hindustan Capital Mill, the Deccans, the Sundaram Finance, and also Drulia judgment, and saying that the trial court cannot go into the merit of the matter, and everything will be decided by the arbitrator, as per section 8
the matter has been referred. The lordship is aware that section 16 is there. So all the jurisdictional issue and other dispute that will be decided by the arbitrator. And on apparent reading of the impugned order, my lord, it is apparent that the very reasoning order has been passed by the learned trial court. So my respectful submission at this stage, my lord, that this order we challenge before the court and need not to be interfered with. And also, the entire matter has been infructuous. Their suit has also been infructuous. In view of the fact that already that notice has been executed, and in pursuance of that notice, the AGM has already been held. It is an admitted part, my lord.
Where is that admission? That's what I'm asking you.
No, that they challenged the notice dated 3rd of February, my lord. Now, in pursuance of the notice, the AGM was held.
That's okay, but very it's on record.
That is not in their pleading.
So that we commit.
But they interim they played before this honorable court, my lord, that not to give in effect of the resolution adopted on 1st of March. Kindly see page 17, my lord.
You've seen that.
Yes. So therefore, though they have not said directly or expressly or impliedly, my lord, but the interim prayer they have made before this honorable court.
Obviously, see, with the nature of prayer made at page 75 onwards, it would mean that we can presume that the suit was filed before the AGM was held.
Correct, my lord. Correct.
So therefore, that will never be a cause of action in the writ petition, in this plaint.
Correct.
And in your objection, see your objection is there at
Yes.
page 114.
Correct, my lord.
This you have
We,
filed.
on 17 we have filed.
Whatever, but
Yes.
21, 2
Before the AGM was there.
before the AGM, so
Yes.
this holding of the AGM is not on record.
Not on record. If law,
We have
in that
difficulty
circumstances, we may file an appeal.
in this arbitration matters, we difficulty in taking note of every submission
My lord.
made at the bar.
In that eventuality, my lord, we may be permitted to file out. Otherwise, admitted fact. Because the impugned order was passed on 23rd of February. That is before the AGM also.
Right.
He raised all questions before the register of farms. This petitioner, the issue raised in the suit, he raised before the register of farms. The register of farms also disposed, upholding the AGM, holding of the AGM. His brother has filed a suit challenging on the same subject matter.
That we have not found here.
Yes, we will all bring everything. Allow us a 1 week time. One of the member, my lord, his friend, he went to arbitration. Section 9 application was filed. His own brother, my lord, he has filed a suit in the civil judge. This suit. On the next day, his brother has filed a same subject matter on the junior division. And the Rane junior division refused. Then went to this honorable court.
Lata, you should not be angry. Bar should felicitate this lovely family.
Therefore, we are before this honorable court.
Sounds much of work to all the lawyers. You just get
Blessing, my lord.
Why raise that issue? We are giving you paradise.
I know.
You can't have objection. Pass orders at 2.
Two.
There is someone waiting in the online. We'll take that matter at 2.
Right.
After that, we'll continue with this.
Right.
Only one judgment I am referring, my lord, that is Boozalan and Hamilton.
Bruce.
Paragraph of Boozalan.
Paragraph 20, my lord. 19th line onwards, my lord, paragraph 20. Starts with but where the issue of arbitrability. We refer our judgments, four judgments, my lord, in the lower court. Before the lower court. If, lordship is on, we may plead before this one. Hindustan Petroleum, Deccan.
Give a copy to the.
Sundaram, my lord. Yes, we'll punish.
Before declaring your order, we'll take that, lawyer was trying to reach online. Yes.
That's paragraph 21 and 22 also. 21, 22, and also 23.
Yes.
Me, please, Your Lordship. Lordship, in item number 49, Lordship, the conducting council is having some connectivity issue, Lordship. Lordship, I humbly pray if this matter may be listed after 2 weeks, since we are also supposed to file additional affidavit, Lordship, bringing on record the plain written statement and arbitral award, Lordship. It was inadvertently omitted. Lordship may kindly condone our omission.
Here made by Miss
A. Pradhan.
A. Pradhan. Now that counsel for the petition. List after 2 weeks so as to enable the petition to bring additional documents on record. I will open it. Just after 2 weeks.
Thank you, Approach.
Time being item.
My lord, I may be excused, my lord. It is not the time for mention, but there is some urgency, my lord. Item number 42, my lord. My lord, decree was passed on 30/4/2022. My lord, due to this CRPIO, my lord, it cannot be executed for 4 years, my lord. My lord, this is the urgency, my lord, if possible, my lord, as a last item before writing, my lord.
Okay.
My lord.
Just inform the other side.
Item 5.
Which are the cases we have relied on?
Yes,
You're not doing that.
three judgments you have placed, my lord. One is 2015.
What is the name of the parties?
Sundaram Finance, my lord, 2015, 14 SSC, right?
Write those down there. And it will- Givens. It is now available. And Mrs. Saikar is only relying on this one.
One, and then my lord,
So please give a list, otherwise.
yes, yes, correct. They'll give the suggestions also.
Then we'll listen tomorrow for delivery orders.
Right. Only one thing, my lord, I'm just ahead. The three judgments we rely, including 2021 judgment of Dakan's papers. The primary, the crux of the judgment says, once the prerequisite of section 8 is satisfied, there is no other option but to that. That the entire,
That is the judgment of which year?
that the 2015 also says, 3 also says, 21 also says, my lord.
Unless I have the, you have a copy of that?
That, we have give it.
You have it on screen? Okay.
May I request the 15, lordship kindly.
Para 15.
No, 2015, 14 SSC 444.
Just tell the
Yes,
paragraph.
paragraph 8 to 10. 9 is referring Magnum leasing this judgment in para 10.
Come to para.
Yes,
Come to para 10.
para 8, 9, 10, my lord.
Just take to the last. It's not there. Please come to the first part. First page. That is the starting page. First one. Please scroll down. Please scroll down. Scroll down again. Okay, Sundaram Finance. Another citation is
Next, my lord, Hindustan Petroleum. In fact, in Sundaram Finance, my lord, Hindustan Petroleum has referred in paragraph 9.
no, but so far as that's why I just recollected because I have been.
No, we have furnished.
No, not that. Since I have been looking at this after some gap, I have forgotten parts of it. Sundaram Finance does not deal with, does not distinguish with the judgment in Booz Allen. In Booz Allen, it says that arbitrability will have to be decided by the court.
Yes.
That has not been touched here.
No, no, correct.
So that Booz Allen is cited by Mr. Saikian.
Yes, correct.
So I wanted to know that in the other cases you have cited, is this Booz Allen been distinguished?
Only in Deccan case, my lord, 2021, in Deccan case, what is right in right in rem and right in personam, that is distinguished.
Can you have that citation?
Yes, yes. In paragraph 9, 2021, my lord.
No citation, give the citation. So
Yes,
my
2021, 4 SSC, 786.
Which paragraph? Of this?
Paragraph 9. No. Paragraph 9 is Deccan. No, sorry.
Down the paragraph 90 be down.
Nine.
Google. No. Where I
Is that screen open for you?
My lord,
Is that screen open for you? You can read that.
no, it's not on.
Screen is off.
Switch on.
First, my lord, paragraph 8.
Okay. Yes, sir.
Paragraph 8. May I read?
Yes, after that.
Paragraph 8, and so for the RAM and personal concern, paragraph 25.
Please come down. No, 25 is down below. Yes. Yes, please go down. Yes.
So what I understood, my lord,
Yes, what is the point you are urging?
no, what I understood, my lord, that if the matter in issue in between a class of person, it is in person. But if it is affects the world at large, then it is there. Now, this issue, the subject matter before the court is, it is within the society matter. So it cannot be said to be an RAM.
In a society,
The right in person and what I understood, my lord, within the class of a person, the class of the person. If it is within the periphery of a class of person, it's right in person. But if it is goes outside, then it is right in person.
is this the Deccan paper authority on the point that if it is in REM, then it is not arbitrable? It's
If RAM is not arbitrable, it is also said by the Brolia case,
in REM, it is not arbitrable.
not arbitrable.
Then this application is able to be allowed then.
Our submission is it is within the periphery of the society. It is not outside the periphery of the society. The arbitration clause.
No, in a society, there can be no law which binds others who are not non-members. So question of, if that is the issue, then the issue of
The members, it is within the members only. So therefore, the internal mechanism is within the clause 25.
no, Mr. Sekya for a moment has not said that he is agitating a right in REM. Because you see, a society regulations cannot bind anybody who is not a member of the society.
Correct.
So they can't bring about any law which
Yes.
which overrides the general law.
Correct.
That is not his argument. Mr. that's not your argument. You will not make a self-defeating argument. You are not on this right of personal and rem.
Yes, yes.
Outside the society,
Yes, yes.
outside the society also.
Yes, that's what I said. When the SDM itself is illegal, all the body, whatever, whosoever deals with that, is dealing with a illegal body. And this is a registered society, creature of a statute as well.
Then ask the query. Mr. Dafa is trying to bring about a distinction between right in personam and right in rem.
I said, my lord, that it is not my personal some right that I have been terminated or I have been denied some benefit or something. What I said that it did not follow the regulations.
That's what I'm saying, that you are not making a self-defeating argument that you are trying to enforce a right in personam or right in rem.
I said it is right in rem. That was argued before the trial court also. My lord.
May I also request, my lord,
Just a moment.
Title to record. Whole person. Not from the one that is sold. The title and whole person is giving. Okay, let me explain. Premises of the PJ cycle and its council assisted by Mr. A.K. Gupta and council for the petitioner. And to be the third and the council assisted by Mr. A. Gaur and council for the respondent. So you have for all the respondents. You have for which respondents? You have for which respondents? All the respondents. Concluded on the special conditions of notice in the matter. Based on 14 526 for very waters. Please give that slip.
We have the latest judgment we have filed number 2025, distinguishing the Bruce case. This is the
Give the citation to Mr. Seki also.
yes,
Whatever you have,
yes.
please action first.
Right. Grateful.
For admission, item 10.
May I please?
Yes.
Execution,
You say that you have been illegally dispossessed.
yes.
While executing a degree.
While executing a decree, my lord, in addition to the land of the decree holder, they also dispossess us from 3 lesser of land based on being identified by the decree holder. Now, when there was an order, my lord, may I take your lordship to the order passed in execution, page 30, page 40, my lord. There was an order passed in the execution case, my lord, 49 of 82. Operative portion. There was a direction given, my lord, page 41, paragraph 4, may I read, my lord? To make a measurement and verification of both the land. There was a direction given by the executing court.
Page 40.
Page 41, my lord.
paragraph 4, order of 2008, man. May I read that now?
Just shows them which part you want to read,
Yes,
which paragraph you want to read.
paragraph 4, my lord. And there
Yes.
paragraph 4 is the, my lord.
Yes, please read.
Yeah. The opposite party decree holder were issued with notices to appear before the court and they apprise the situation who accordingly filed written objection denying everything. It is the contention of the decree holder that the petition is not maintainable in law and in fact. The same is not filed so and so and in accordance with prescribed procedural law. It is the plea of the decree holder that the objectors have no right or locus standi to file the instant petition. It is a plea of the decree holder that the objectors submitted a petition suppressing real fact and as such, petition is liable to reject. The plea of the decree holder is that their predecessor, namely so and so, came into occupation of a plot of land measuring 3 lesser forward by Dag number so and so, situated at Kalibari Road, Dibrugarh Town, Moza, Dibrugarh, and started residing therein by constructing residential house, covered by holding number 44 of ward number so and so, and another plot of land measuring 2 kotha, covered by Dag number so and so, situated in the same place. It is a plea of the decree holder that in between their land and the land owned and possessed by the objectors, there is an E&D drain, my lord, the town protection drain, my lord. And as such, it is clear that the land of the objectors have no relation or connection with the land of the decree holder. It is a plea of the decree holder that on some occasion the objector tried to occupy a part of the land owned by them but failed. However, on 25/2/2007 at 9 am, the objectors by using so and so tried to occupy portion of land described in so and so. Again, on 5/3, the objector armed with so and so entered in the house where decree holder and they are trying to occupy the said house forcefully. In this regard, the decree holders as plaintiff filed 2 complaint case before the learned CGM Dibrugarh and 1 titled civil suit being titled suit 23 of 2007, which is pending before learned Munsif Dibrugarh for disposal. Now, it is a plea of the decree holder that as per order of the competent court, including the Honorable High Court, in favor of the plaintiff judgment debtor vacated the suit house and according Nazir handed over the possession of the said land and premises to them. It is also the contents of decree order. Although on 28/9/2007, the objector filed written objection written in a court of learned Munsif to Dibrugarh, they did not utter a single word pertaining to allegation as well as in the petition. Now, it is a contest of decree like considering all aspect matter, it is clear that the petition is based on so and so. Now, may I come to your lordship, the conclusion, page 44, my lord.
You see, please come to page 48.
48, my lord.
Issue number 3 and 4. Please
Yes.
read that.
Issue number 3 and 4.
3 and 4.
Yes. It is in this case, party has led order by regarding the identity of suit land, dark patta, the circle officer spot verification is most vital to decide in this case. Plaintiff claimed that suit land is of him, falls in dark number 430, whereas defendant denies the same. In spot verification report, a circle officer submitted the suit land with Ted's house fall in dark number 441 or PP number 159. 44 of dark number so and so, not under dark number 40 of Marwari Patti so and so. To which DW affirming cross as DW1 deposed in cross that a disputed land dark number in so and so. The DW affirmed evidence the land of the defendant boundary by North Kalibari Road, south of plaintiff and west, there is a E&D drain. DW1 deposed in cross the suit land is attached with his land, implying that suit lands fall under defendants. The cross of PW deposed the defendant at Mohammed Ilyas. This is the present petition. Title execution 4982, alleging that the land in patta number so and so was disposed for which the court passed order in 12/5 for the defendant. We saw the suit lands fall in dock number so and so as claimed by defendant, not under dock number 436 as alleged by plaintiff, where the defendants are residing by own right. The DW support the commission report to which plaintiff has no objection report and its affirming aiding so and so that commissioner report is admissible as substantive plea without examining the commissioner. So I want to view that these two issues go with against the
If we
plaintiff,
just stop here. If I have understood correctly,
my lord.
the judgment and decree put into execution is page 46.
Page 40. No, my lord. My lord, may I come to this? When this demarcation order was been passed by the executing court, to overcome that order, they approached Gauhati High Court revision and also filed another title suit against us, arraying us a defendant. And that title suit page 46.
Page
46.
Second suit.
Second suit, they implemented as defendant and filed this suit. But that suit was dismissed, my lord, against their plaintiff.
The suit was dismissed.
Yes. And even to overcome the demarcation order, my lord, they file a revision matter against that order. In that order, your lordship will find page 59, my lord.
In this record,
Yes.
we don't find a trace map with regard to your claim that the land
Yes.
which you disposes
Yes.
is outside, you said is between the declared land and dock number 441.
Yes.
So that map I did not find. In the trial court also record, I tried to see, don't get it.
There is a, I have annexed one map, my lord,
Where is it?
page 98, lordship. But even they have not examined the circle officer, my lord. That's the thing is that, my lord. Page 98. And the original copy, page 99.
The 99, which is your land?
Our land,
Which
my
is
lord.
Schedule B.
Yes, Schedule B. Land of
one?
the objectors.
Which one?
Schedule B, dock number 441, my lord.
Is
Area of
that-
land 3 lesser.
In this map, which is 441?
Schedule B, my lord. It's in vernacular, my lord. First one, dock number 441. Could
We
not be-
understand 441,
Yes.
but which is that 441 in your map?
That has not been, circle officer has not, that is the grievance, my lord. Even, my lord, we filed petition for examination of the circle officer, my lord. Even that was not allowed, my lord.
You see, it is your projection that between these two dark is still lesser land,
Yes,
which is yours,
yes.
correct? So this shows any material from which it can be substantiated.
Yes, my lord, that your lordship will see, my lord. The lordship will kindly, consider page 62 of earlier High Court order, my lord. Pursuant to this only, this exercise has begun, my lord. Page 62, my lord. Last paragraph.
62.
Yes, my lord. In the revision filed by the decree holder against us, my lord, to stop the demarcation. Now, in that case, paragraph 11, my lord. Paragraph 10 onwards, page 62, my lord. May I read, my lord? In the above circumstances, I do not find any infirmity with the impugned direction of the executing court, whereby the Nazir and the revenue staff were directed to identify and measure the decretal land in order to verify whether the objectors were wrongfully dispossessed from their own land covered by different dock number and patta number. We have different dock. If the order exercise reveals that objectors were wrongfully dispossessed from land which is not covered by the decree obtained by decree holder in the title suit 27 or 81, objectors are certainly entitled to restoration of possession. In the instant case, the order exercise is still to be undertaken.
because of the interim order passed on 1/8/2008. Therefore, the objector claim for restoration of possession is directed to be considered by the executing court only after Nazir and the revenue staff verify and measure both the decretal land covered by DAG number 436, PP number 158, and also the adjacent land of the objectors covered by DAG number 441 and periodic patta 1559. This should be done in process of both parties. If the verification process revealed that the objectors were wrongfully dispossessed from land not covered by the decree, the restoration of property should be granted to the objectors. But this exercise carried out on 26 is within the decretal land. With the above revision, petition stands disposed of without interfering. So they, my lord, immediately file revision, selling the order of executing court, passing for verification and measurement. Now, not only that, after disposal of revision, my lord, no, during pendency of revision, they also file another suit, which I have shown, my lordship, title suit, and that title suit was also dismissed. That is phase 46, my lord. Now, my lord, after that, my lord, page 60 for your lordship.
Is the print of the second suit, page 46 is available?
Yes, my lord.
Where is that?
My lord, date. Page 49, that was disposed of, my lord. Page 49, last one.
I'm asking, where is the, do you have a copy of the plaint of title suit date of 88?
Then I don't know. Because suit was filed by. The schedule is there, my lord, page 57.
Page number?
57 is the schedule of the decree, my lord. Where they hide our objector's land, my lord.
Where is the objection to execution? Where is that?
Yes, my lord, our petition, my lord. Page 33, my lord.
33.
33, my lord. Annexure 2. And lordship, page 60 for your, if your lordship come, that was the direction given by executing court.
Yes, what do you say?
May please, Your Lordship. Lordship, it page 72, Your Lordship. It is the order of 2/11/2016. That exercise was done and accordingly report was submitted and order was also passed, which is not challenged by the petitioners. Page 72, Your Lordship. May I please, Your Lordship. May I please, Your Lordship.
But where is the report of the lot control? Where is the report?
In the order, Lordship, it is reflected, page 73, paragraph 3. It appears from the reports that the demarcation was done by observing proper formalities. There appears nothing on record which would indicate that there arose some problem in the measurement of the said lands, Schedule A and Schedule B, due to the existence of E&D drain pertaining to the apprehension of the
No, not on
objector.
that. I just wanted to know where is that report of the
Report, Lordship, report
of 2012? Where is that report?
only in the order sheet it is reflected about report, Lordship.
Worship may find on page 100, maybe that was submitted as circle office. Page 100 is the translated copy.
Page 104, Your Lordship, that report. Arnigolan. And type copy 103.
There was a E&D drain, madam. That was not mentioned, madam.
In the report, Lordship, it is submitted Chukma Korute Mapot E&D reservation Dekhapua Nai. That was submitted. And that report was not challenged.
May second,
Maybe don't stand a chance.
page 100 may second.
Maybe don't stand a chance. Page 102 shows that you don't have a chance.
No.
This was made and then there's no ENT drain and
Yes, yes, ma'am. We say, Malad, there is a END drain.
it's not there. If 102 is not objected to, then it seems your fate.
This is not correct, Malad, because may I point your lordship?
Who will say it is not correct?
Yes, sir. There is, in that report, my lord, may I say, 2 katha, 3 katha, lesser or land is mentioned. Whereas in the page 105, your lordship will see, that report has hide that there is 3 katha of land, my lord, 105 page. This is a RTI report submitted by circle officer. So they are hiding the land of the objectors.
No. That can't be presumed. Because this is the, when the Nazir and the circle officer goes
Yes,
and does a commission, it finds out the measurement as is available.
yes,
And the certificate 105 says as per the revenue records.
yes.
There may be a mismatch in the revenue records and the actual landed site.
105 says there is 3 katha of land.
Mr.
Under-
Vora, the question is very simple. The High Court directed that the examination be made. Examination was made. This report has come. This report becomes an evidence by default. This evidence is not challenged. How do you stand your case?
No. We challenge the impugn order, mother, where the report of the
Perhaps-
circle officer.
Perhaps the approach is wrong. You have CPC with you.
I have not.
See order 26 to 10 to,
That application also we have filed, madam, for examination of circle officer.
what happened to that pair? Where is that pair?
Order 26 also we wanted to call for the circle officer for examination. That was not allowed, madam. Your lordship will find page 69, madam. That is the thing, my lord. If the circle officer is examined, then things should have to page 69, my lord, and page 70. Paragraph 3, 4, 5. There are 5, my lord. We have stated in
Was the order passed in page 69 petition?
page 16. Okay. I understand that was not allowed. Perhaps
No, but whatever it went to
My
make
lord.
that statement, please complete that part.
I can.
Mr. Bora, which page is the order which is under challenge?
My lord, your lordship page 117, madam. Order dated 2/5/2022.
Date 7,
170.
17.
Yes.
is becoming very difficult to keep a track of the orders and petitions, because this is an execution of 1982. We have been filing petitions since 2007.
2007, and they stopped it by.
And your case, when we read these orders, we find that you filed an execution, in the execution petition, you filed an objection. Subsequently, long thereafter, you filed an application for amendment of the petition of 2007.
Amendment of the petition of.
And after 2007, there are two orders of what you call demarcation, and twice demarcation was held. First is with on the basis of the High Court order. Second is with the direction to have the demarcation with the help of the circle officer and the EMD.
Yeah.
So there are a lot of dates which are coming up. You both of you make a list of dates and give it to us.
May I place today, I have got one list of dates. I have prepared one list of dates. Today, may
You show it to
I'll
him
give
first.
him a copy.
Let him approve of it. If it is okay, then we'll take it up. Otherwise, it becomes very, give a copy to him. No, don't give it to me. Give it to him first. We'll take it up tomorrow. You just check it up. If the list of dates, make a complete list of dates and give it to me.
Lordship.
What is the date and what is the petition? What is the order and what is the and the page numbers, wherever is relevant in this revision petition.
I have mentioned,
It's okay, but once I am making notes, I find it very difficult because the documents are also not in serial order. It's not date-wise, it's not easy to find out.
And the executing court, my lord, while concluding, said that he has no power for extension. That is also, my lord, without.
So not that, but if there's a what do you call demarcation, and there is a finding of fact which is supported by because of the orders of the court, then this will have that will have more importance. What you do is to frustrate that. You file another petition and get it allowed to have another demarcation with EMD.
No, my lord, thing is that there was a EMD drain that has been not shown in the report. That's why we wanted that circle officer be examined. That was
But
not.
that order, we are not finding it. We have made a search, we did not find that order.
Perhaps, my lord, in record. I may well also allow, then I will take it today. And had the circle officer and lot bundle be examined, my lord, then it could have been, my lord, logically concluded. My lord. And all the question has to be determined by the executing court.
No, you are complicating things. That means you don't have a land. Otherwise, you will not complicate things. In 2016, the parties come to court, get an order for demarcation. At that time, you don't do anything. 2018, you bring and record another map, and then you say that this is my document number 441. Then there are two reports which doesn't say about the EMD drain. And then you say that the land is there, you bring this, therefore you see, you don't have a case, that's why you are manufacturing one.
No, my lord, that map was pursuant to order of the circle officer, court.
But why, if
It is
you
submitted
see,
to court.
if that first commission report
Yes.
is an evidence, why you need another evidence to take care of the first evidence? It is at your instance that this evidence has come. Now you disbelieve that and you bring the second, so you want a second report, you want a third report.
No, we want, my lord, that the circle officer.
No, it is, we call it in English beating around the bush. You just have a stick and you start beating around the bush and then you say that this is my land, that is my land. You don't have an idea of your land.
The learned.
It's not your case that the demarcation was, when it was made, it was in your absence.
No, I was present, but.
So if you are present,
Drain, my lord, they are not. So I have objected, my lord, that there is a day where 3 lakhs of land has been, my lord, they have not taken into account. Therefore, we wanted to examine the circle officer and documentor. Because, my lord, it's a, under executing court has
No.
the question.
There is nothing on record. That's why I wanted this list of dates now. There is nothing on record to show that from a particular pillar,
No.
this measurement was, you made an effort to have this measured from a notified pillar and then to find out. That exercise, we don't find it here. And therefore, the mandal comes and gives a report that this is there and that the correctness of that report is not questioned. You instead want a second report to come.
You objected, my lord, by filing
But
objection.
that's okay. Give me a list of dates.
My lord.
Otherwise, very difficult for me to have the point of hearing to have list of dates from 2008, what do you call 2006 to 2018. It will take me months to do it. So please prepare it and bring it tomorrow. Just bring it tomorrow. Both sides are represented. It appears from the records of the title execution case number 49 of 1982 that lot of events has taken place for last 40, for almost 40 years with multiple documents and petitions on record. So therefore, for the ease of understanding, or the court directs both sides to prepare a list of dates and produce it before the court on the next date of listing. Next para. Both sides are put to notice that any document which is not mentioned in the list of dates shall not be considered for adjudication of this matter. Next para, list on 14/5/2026. Mr. Dates, Mr. Date indicating the page number.
My lord, next Wednesday.
You see, I have heard it, I will forget. I won't remember. I have a very weak memory.
So, application 20 of.
I have a very weak memory. I will forget.
Oh, my lord.
You know us. We have a very weak memory. Next day again, we'll have to hear everything.
My lord.
For admission, item 12.
Your Honor.
What is the ground on which you are seeking transfer?
You have also raised the transfer petition filed by the wife, who is the respondent in the matrimonial proceeding in FC case number 1236 of 25 in family court.
We are asking what are the grounds on which you are asking?
Your Honor, she has full custody of her child, who is a
Of?
premature baby, and she is working in Goalpara as a government B.Ed teacher in government Goalpara B.Ed college. And it's practically impossible for her to travel to Gauhati on every day. And moreover, she has full custody of her child, who is a premature baby who was born only on 27 weeks and was admitted in NICU for almost 61 days. And it has been prescribed by the doctor that he doesn't travel frequently. And moreover,
Where is that?
it's
Where is the document of the baby?
Your Honor, it's on page number 38, Annex 9. At the 38.
What is the date of birth of the baby?
Give me a minute, Your Honor. It's 22/11/2023. 2023, when the baby was born. He was prematurely born on 27 weeks.
Pardon me, please tell again, what is the date of birth of the baby?
22/11/2023.
23.
Yes, Your Honor.
Yes, any issue with regard to the pair for transfer?
No, Lordship, we have no objection. If you the child to help, we have no objection.
Okay, good. We appreciate that. You are Mr. A. Khanikar.
Yes, Your Honor.
Heard Mr. A. Khanikar, learned counsel for the uh, petitioner. Also heard Mr.
Yes, Arafat.
S.
Arafat.
R.
Arafat.
S. Arafat.
Yes.
Learned counsel appearing for the sole respondent. Your Vakalatnama is not available here.
Only yesterday we have filed a Vakalatnama actually.
You filed your Vakalatnama yesterday.
Yes, sir.
You have your bar enrollment number with you,
Yes, sir. 1295 April.
having bar enrollment number
1295 of 2018.
2002. So who submits that his Vakalatnama has been filed before the registry yesterday. Next para. The petitioner, who is the estranged wife of the respondent, is seeking transfer of the matrimonial proceedings of FC Civil case number 1236 of 2025, which is an application under section 13 within bracket 1, numerical 1, again bracket small IA, bracket of the Hindu Marriage Act, read with section 27 within bracket 1 within bracket small d, the Special Marriage Act, 1954, for dissolution of marriage between the parties, which was instituted by the respondent before the family court at Gauhati, which is pending for adjudication before the learned principal judge, family court, Roman 3, Kamrup Metro, Gauhati. Next paragraph. It is projected in this application that the parties have a minor child, female child, which is prematurely born in 27 weeks on 22/11/2023, and as the petitioner is employed at petitioner is employed at
Gwalpara, Your Honor.
in which office?
District Judge.
In the office of the district judge, Gwalpara. He is unable to travel with the premature baby. And he also projects that he is also suffering from several illnesses.
I'm sorry, Your Honor. I'll just interrupt you. I just mistook the district judge thing.
She works in the government B.Ed college.
The
I,
government-
by,
Okay,
by
government
mistake,
B.Ed college at
Gwalpara, Gwalpara.
Okay. Next para. The learned counsel for the respondent, upon instruction, submits that the petitioner has no objection, the respondent has no objection to the allowing of the prayer made in this application. Next, accordingly, in exercise of power under section 24 of the CPC, as not objected to, the proceedings of FC within bracket civil bracket case number 1236 of the 2025 pending for adjudication before the learned principal judge, family court C, Roman C, Kamrup Metro, Gauhati, is transferred to the court of learned district judge, Gwalpara, for the adjudication. Next para. The parties are directed to appear before the court of learned principal judge, family court 3, Kamrup Metro, Gauhati, in person or through their learned counsel on, tell a date when you can fix it so that you can appear and get a transfer. 29th of May,
Yes, sir.
on 29/5/2026. So on the said date, the petitioner shall produce a certified copy of the order before the said learned court. Next, on the on being furnished with the certified copy of the order, the learned principal judge, family court C, Kamrup Metro, Gauhati shall transfer the proceedings to the court of learned district judge, Gwalpara, after fixing a date of appearance of the parties before the said learned transferee court. Transferee EWD, transferee court. And also transmit the records to the said learned court. Next paragraph. Application steps allowed. Next paragraph, we should know about cost.
Obliged, Your Honor.
For admission, item 13.
This decision is filed under Article
Which
225.
page is the order dated 9/10/2024?
24, Your Lordship, is based on 230, my lord.
230.
257 starts here, okay, in the last. Means the case number 06/2024.
Can there be a section 5 application for filing of a suit?
Yes, my experience is that section 5 will not come, section 3 will come of the Limitation Act. Because there is a statutory bar after 90 days. Because you have to file an appeal before the district judge within 90 days. Once you miss the bus, you miss the bus now. Lordship,
Let us see section 5 of the Limitation Act. Where do you get that provision? Limitation to file a suit.
actually, first of all, my lord,
Let him,
oh,
let
sorry.
us go away complete this part. Otherwise, you'll have to come here and then argue and then go back. If you want to take that liberty, we will be giving it to you.
Yes.
Yes, section 5.
May I read your lordship?
Yes.
Extension of prescribed period in certain cases. Any appeal or any application other than application under any of the provisions of order 21 of the Code of Civil Procedure.
So according to you, the suit is an appeal, it is an application.
Is in a lordship, it is in a condonation delay petition, file miss case,
We understand, but you have filed a money suit.
money suit, your lordship.
Money suit, according to you, reading section 5,
Lordship,
is what? It is an appeal or application?
it's an application, your lordship.
Suit is an application.
Lordship, I have said the order miss the case number 06 oblique around the money suit of 1 oblique 2024. And the condonation delay petition.
You see, after about quarter of a century putting in here,
I wait to apply to lordship. It is suit.
first time we have come to know that a suit is an application.
No, lordship, it is a suit is an appeal 01 oblique 2024 we had filed. And thereafter condonation delay has been filed on the ground that in earlier case we had filed in a money suit.
Under which? Yes, please continue.
Earlier, you had filed in a case in magistrate in another forum that is not maintainable as per the Petroleum Act 1962. Since it is a case of the district judge to be there as a reference court to be maintainable, we have to file in that court. After briefing of this case in another court, your lordship, that this case has been referred to the civil judge as a senior division. And according to the district civil judge has referred to the this additional district judge.
Where was that suit filed and what is the number?
So it is a lordship in that case. It is a, in that case, your lordship, it is. Page number,
Just tell me the suit number and the date in which it was closed.
money suit 1 oblique 2024, annex of 1,
2024.
yes. And page 28, my lord.
No, it's okay. We don't need that.
Then thereafter,
Filed money suit 1 of 2024.
lordship. Thereafter,
You filed this miss case on 6 of 2024,
lordship,
same year.
state.
So how does 707 days come?
Lordship, it is a wrong calculation by the registry. It is around 534 days has to be condoned by the honorable court, but there have not been.
If it is a suit of 2024 and you filed miss case also in 2024, how can there be 500 days in a year?
Lordship, date of the disbursement of the money which have been applied as per the Petroleum Act. As per the Petroleum Act 1962, the date of the amount which have been received by the compensated person, your lordship, from that day to from the till the filing of this case. That around 707 days.
No, sorry, then you don't have a case. There can't be an application under section 5 for filing a suit.
Lordship, we had filed a case before the trial court on the ground of 707 days, and that is ought to be condoned on 534 days, your lordship. That has been during the period.
Not even a day. The suit cannot be condoned even for a day. You can have extension for limitation, you can have benefit of section 6, section 11 or something, anything which you want, 14. But you can't have extension of time under section 5 of the Limitation Act.
In that case, your lord, I want to place one judgment. If lordship permit you.
Please.
First judgment I want to place, my lord. Oman Kunjarma versus Deputy Collector and Competent on 28th February 2019 is at Kerala High Court, whereby in the same cause of action in the Petroleum Act, I just referred to page paragraph 24, last observations, your lordship. May I read your lordship? We cannot accept the contention of the learned senior counsel for the responsibility that the expression not
Just
that,
a moment.
Lord,
Yes.
then you will also the second judgment I want to place, that is Murli Gopalan versus on 12th July 1995. Last part you will also is the observation part. If lordship permit you also. As a result of the aforesaid discussion, it must be held that the appellate authority constitutes under section 18 of the Kerala Rental Act 1965 function as a code and period of limitation period wherein section 18 governing appeals by the aggrieved parties will be completed keeping in view the provisions of 4 to 24 of the Limitation Act 1963. Such proceedings will affect section 29(2) of the Limitation Act, and consequently section 5 of the Limitation Act would also be applicable to such proceedings. So it cannot be in this
Paragraph.
last paragraph, my lord. Last paragraph of the observation passed by the Murli Gopalan and this one, your lordship. Last paragraph, as a result of the aforesaid discussions. Lordship got it, you understand? Last paragraph. Last page of the judgment of the law. In that,
This is under the Petroleum Act.
yes, sir. Specific act cannot be a mandatory. It can be a
Petroleum Act.
directory, your lordship.
Petroleum Act.
1962. The main contention by the respondent under section part by the 10(2). my earlier judgment, that for has been covered by this act, Your Lordship. Oman Kulam Janam, the deputy collector will be squarely covered. It fit with my case, my lord. এখন দেখো পেট্রোলিয়াম এখন কে দিছো my lord.
Just a moment. I have my own book, it's always good. This big hook. It's not here. Please pass over your book. No. Where is the notification to you about the compensation? Where is that?
Your Lordship, it is uh, 103, my lord,
103.
page. 103, 104, 105. Countersigned by competent authority, my lord, as well as Gaumbura of Elaka area, the reason of the.
No, this does not determine your compensation. Where is that notice to you for that compensation?
Lordship,
They'll be making an assessment and giving it to you. Where is that?
notice have been issued, your lordship, thereafter, without any compensation.
No, it can't be. Because you have received the amount of rupees 5,99,000.
Lordship. The issue is that we have raised objection. My lord, in that case,
No, I'm not on that. I have a specific question. It's a targeted question and please respond to that.
the amount have been received, 5,99,700.
You see, unless there is a notification, you will not receive it. You will be getting an intimation of the compensation made. That is something which is in exercise of power under Rule 4.
Lordship,
And the limitation runs from that notice of Rule 4.
lordship. Then thereafter,
So where is that? You are calculating a limitation from a particular date.
from that amount which have been received, 109.
That doesn't create that. You see, in a LA award, the award may be made 10 years back, but you are receiving money now.
Lordship.
So your right to agitate starts from the date of your notification of that. So that's why we are asking you a very
There is no
pointed
notification,
question.
my lord. There is no notification after
It has to
being.
be. It has to be, otherwise in the Deputy Commissioner's office, you don't get any money without a notification.
No, we have not received, whatever we have received, we place before the Solapur court as well as the trial court. Now, my learned friend will produce that document, whether what notification I have been received, that amount have been ascertained. And we made a complaint before the competent authority. Since competent authority is a quasi judicial, my lord. And we supposed to think about the day or.
You see, the entire premises on which your suit is made appears to be defective. Number one, somewhere I have read that you said that when you received this money, you raised an objection before the Gauhati.
Yes,
Gauhati is not the competent authority to take an objection. You received the money from a collector. So
Lord.
your protest must be registered not before the Gauhati, but before the collector.
we have mentioned, your lordship, yeah, if 120. Page 120.
120.
11/10/2022, my lord. This is the whole Gauhati has objected regarding the payment. And English portion is at 118.
Then you have no case at all. If this is what you are showing us. You see this objection,
Lordship,
assuming that this is given to the Deputy Commissioner, he is on 11/10/2022,
lordship,
correct?
lordship.
As per the page 112, the date on which you received compensation is 11/12/2021.
Lordship,
So this objection is raised after 10 months.
lordship.
A protest can't be made after receiving money. You have to make a protest and then take money.
Lordship. Now, if lordship permit me, there are some notifications where they had supposed to, their notification, your lordship. It is on page 121. They assured us by the deputy commissioner that 3 crops cultivation will be accommodated to give a compensation where our land has been done. This notification by Assamese in 28/10/2021. As per this notification, my lord, we have given notification to the, we have complained to the deputy commissioner since he is a quasi judicial as a competent authority. And after being not intimidated anywhere, my lord, directly they paid the amount. Then thereafter, we have repeated, since Gauhati,
You received the money,
my lord,
you received the money. This, the document you are showing at page 121 is dated 26/10/2021.
no, this is a,
What
lord,
is the date? 26/10/2021. You received money on 11/12/2021 after 2 months.
lordship. And they are prior to
And
that,
then after 10 months, you make a protest.
prior
I
to.
don't know.
My lord, prior to that, we have made a whole Gauhati protects against that
Why
compensation.
Gauhati? You can even write to Prime Minister, President of India.
Lordship,
Why trouble the poor man Gauhati?
lordship, since the people are interested, person are illiterate. Only the bank account have been done. It is a fair case, my lord. If it is a technical purpose in this case, then it is a different issue. See, even the Supreme Court judgment also says that Section 5 of the Limitation Act not is any mandatory in this case, although it is a especially statutory.
No. What you did was right, but what you subsequently did was wrong. This reference under the Petroleum Act or the Pipelines Act
Lordship,
is before the Deputy Commissioner.
Lordship,
Sorry, district judge.
district judge.
A district judge cannot what you call, refuse to take it up. But you withdraw it and you file a money suit. Once you file a money suit, then the Limitation Act would have no application at all.
Lordship, again, I want to retrospect my submission that 2A of the quasi-judicial, it is there in the Petroleum Act. The quasi-judicial itself says, Your Lordship, not only the deputy or not only the competent authority, also DC, then also the other persons are there. And I have filed it before there.
You withdraw it and you file a money suit. In a suit, there can be no application under Section 5.
Lordship, since my day condoned have been, the delay has been condoned, been wrongly been delayed for long that days. So I have no, but until and unless my condone be delayed, that the judgment says in the Omkara judgment. That the judgment says in the Petroleum Act 1962, Your Lordship. Even Tripura High Court also, I have mentioned by it, Lordship, permit me, even a Tripura High Court in that case also, same case of action, have been condoned. Page 18. I have not taken this today. 18. Page 18 of my memorandum application. There are 3 judgments I have been mentioned, Your Lordship. If Lordship, it has been paragraph number 16. May I read, Your Lordship? In view of this, even if any person receives an amount on account of compensation without having the said intimation in the manner as observed, it would not limit the person to approach the district judge for determination of compensation in terms of Section 10(3) of the PMP Act. Rule 5 of the said rules has prescribed the period of limitation of 90 days of the receipt of intimation from the competent authority by the aggrieved party under Rule 4(3). Rule 3 of the 4 provides that the competent authority shall, on receipt of claim for compensation such inquiry, Lordship, as prescribed and fix the compensation thereafter, inform the parties, refer to the subsection 2 and 5 of the Section 10 of the amount compensation so fixed. Further, as correctly pointed out by the learned counsel for the respondents, the division bench of Kerala High Court as well as learned single bench of the court have been held that the Section 5 of the Limitation Act would be applicable in the context of application for the compensation under subsection 2 of the 10 of the Act. This is the judgment by the Tripura High Court, Your Lordship. Even in the another judgment also it has been there, paragraph 17. In the case of ONGC versus Nimail Borman, reported in 2019, legal Tripura 667, paragraph number 16. May I read, Your Lordship? It deals with an appeals on, it deals with all appeals or any application. A petition under Section 10(2) would, in my opinion, be an application within the meaning of Section 5 of the Limitation Act. Section 14 also applies to suits. There can be no problem with this regard. Therefore, I am on the considered view that the application under Section 5 of the Limitation Act is maintainable. With due respect to the consideration, explanation rendered by the respondent for delay at the hands of the last district judge, no serious arguments are advanced. Even otherwise, in excess of jurisdiction, I did not find any error having committed by the learned district judge in filing of the said application under the Act, purely simply because such application for continuation delay was filed at a later stage could not be ground to be rejected. So my humble submission is that the enabling of court, since it is a quasi-judicial of the competent authority, although my learned friend has mentioned in the said impugned judgment from the day to the court have not been discussed properly. For that ground, it has been decided dismissed, Your Lordship, not on the merit, Your Lordship. My humble submission is that if 1962 Petroleum Act, for the purpose of suppose a person who doesn't know about the cases, then definitely he approached before not to be, ought to be after 90 days, he ought to be go to the district judge, not to the quasi-judicial approach people. Because there is a section, Your Lordship. And they mention it a quasi-judicial in the affidavit in opposition, Your Lordship. This is not my case in hand that I am specifying that. It is their case. If Lordship permit me 134, their affidavit in opposition in that, in the trial court, your lordship. What they mean about the competent authority here?
Page number?
134. Their objection here on the maintainability of the petition, your lordship. May I read your lordship? 2. No suit or other legal proceedings shall lie against the central government, the competent authority, or any state government or corporation, or any damage, loss, or injury caused in likely to be caused by anything which is in good faith done or intended to be done in a pursuance to the act or any rule or notification made or issued thereunder. The competent authority is a quasi-judicial authority appointed under Section 2A of the Petroleum and Mineral Act 1962 to deal with the matters to acquisition of right of user in land, exercising his power under Section 3 and 6, hearing of objection, my lord, under Section 5 of the PMP Act 1962, and deciding the compensation amount under Section 10 on payment of the compensation, 11 of the PMP Act, and have been empowered under Section 12 to certain powers of civil courts, my lord, while trying a suit or objection and conducting the hearing of the matter, and as such the as per section 13 is protected to action taken in a good faith. So we, after doing file, there is no intimation, my lord. If they intimated in a single piece of paper also, then it is a case of different. But they himself admitted the quasi-judicial, my lord, in the Act of the 2A, in the definition, my lord. So before entering to the district judge as a reference court, there is a chance to objection of hearing, your lordship, in the quasi-judicial manner, quasi-judicial authority. These are not a technically piece to that after being aggrieved, it can be go to the reference court, 90 days. And Supreme Court as well as Tripura High Court and other courts also clearly mentioned about the Section 5 of the limitation that is not a mandatory, is a directory, your lordship, in this reference case. I may be allowed to, my only humble submission is I come with a very limited pair. The entire judgment which has been passed by the trial court, nothing, only quoted both the cases, and just in that last line, this petition is not maintainable. So my humble submission is, I have been aggrieved, your lordship. And interestingly, I have mentioned, my lord, one pipe has been installed, then another second pipe has also been installed without intimation of the second pipe also. And they also, in the Petroleum Act, there is a bar, your lordship. I cannot do any development of the land of that point, your lordship. My whole land has been vanished, barren, become agricultural land to be a barren land, my lord. And this is not the case in that area, entire area of Golaghat district, I can say, your lordship. I have mentioned in all the pleadings in the trial court.
Under the Petroleum Act, what they require is the right of way.
Right of way, your lordship.
If the right of way is covers the area where the second pipe can be led.
But second pipe,
Difficulty in that.
but second pipe can be done only when there is an intimation, your lordship.
On a right of way,
The right of way, your lordship, I understand.
not where there is a right of way.
I understand, your lordship, they can do. We have not been objection since it is a welfare estate. But issue remains is that, your lordship, my whole agricultural land, is it compensation to whatever, about 5,99,000, is it compensation to my entire life, your lordship?
Yes, Mr. Right.
First of all, my lord,
In this document, Mr. Gauhati says that the Section 4(1) notification was never issued, intimating him about the compensation assessed.
as such, but I don't think there is any letter of intimating under Section 4(3). That is the matter, because, but it is an admitted fact that he received the compensation on my law.
No, what has to be done in accordance with law has to be done.
And before that, my lord, he has executed all documents, Panchanama, his identification, indemnity bond, all he has given. Thereafter only money is
It is not like that just one day I went and deposited the money in the bank. So he has to do Panchanama of the plot indemnity bond declaration and all that, then only the money will be sent to his bank. Now the question is that, my lord, first of all, my lord, money suit is not maintainable. Because he should have filed an application under 4.2 and 10.2 and 10.5 of the Petroleum Rules, my lord, 1932. So he has not filed that, but instead he filed a money suit, and then there is a delay condonation of money suit, my lord. Section 5 application has been filed in the money suit, my lord. Lordship may come to section 10 and 2 and 10.5, my lord.
You have not taken that stand that he has complied with all the formalities before release of that money. Your objection, the trial court don't say that.
That is always the mandate, my lord, and we do it, my lord.
Where is that?
I'll just, my lord, just Lordship will give me just. Lordship may come to page 140.
140.
140, my lord.
Yes.
Lordship, I'm reading it, my lord. Fifth line, my lord. Further, as per provision.
Yes.
As per provisions of section 10(3)(1) of the Petroleum and Mineral Pipeline Acquisition of Right of User in Land Act 62, the defendant number 1 and 2 also act under the provisions of compensation for removal of trees, crops, if any, over the land is assessed during Panchanama under 4A2A of the Petroleum Mineral Rules Pipeline Acquisition Right of Users and Rule 1963. Now, my lord, if he is asking for compensation, then he has to comply. Rule, my lord. I'll come to that, my lord. Rule.
You see, the first requirement to come to court doesn't emanate from there. It's
4.2.
It's after compliance of Rule 4.3.
Yes. Rule 4.2. May I read, my lord?
4.3.
4.3. Well, before that, 4.2 is there, that, my lord. The claim for compensation shall be made in the form prescribed in the schedule annexed to these rules. So there is no application under schedule. The schedule is there, my lord, because schedule A has to be prepared under 4A, my lord. Schedule is there, schedule is there, and the 4A says that, my lord, while conducting, my lord, 4A.
You see, it is 4.3.
4.3 is connected with 4A, 4.2.
No, we don't know. Unless you read 4.3, we can't go to 4A. That is after that.
After that, after 2, after 3. After 2, after 3.
Please read 4.3.
4.3. 4.3, I'm reading it, my lord. The competent authority shall, on receipt of the claim for compensation, make such inquiry as provided in Rule 4A and fix the compensation, and thereafter inform the parties referred to in subsection 2 and 5 of section 10 of the amount compensation so fixed.
It is after this.
After this, but there is no application from their side in schedule as per Rule 4.2, my lord. Now 4.3 has to be done as per 4A, my lord.
In 4.2, there is no requirement of him to object.
Yes, but there is, at that relevant point of time, he has not made any application, and anything that his compensation, he should get this much. That is 4.2.
That is not required. That would mean that you want to say that a citizen would doubt the government of India undertaking, that they will do wrong.
No, it's not that.
How will I make an assessment?
Yes.
Supposing today in the argument this gets lost, this one. I blame that Mr. Roy has damaged this. Correct. Now, will I or you, who will be competent to make the assessment of this loss?
It is on either the party whose thing is damaged.
It will be registry who will find out this
Yes,
loss.
and from the asset,
And
yes.
then you will have to be informed that, Mr. Roy, this caused us, the court, loss of 10 rupees. That is an intimation, in
Yes.
letter 4(3).
So we, madam, as per 4(3), madam, we have,
4(3), comes, this, please come to 5,
rule 5, my lord.
rule 5.
Yes. A party aggrieved by the determination of the amount of compensation may prefer an application to the district judge within the limits of whose jurisdiction the land or any part thereof is situated, not later than 90 days of the receipt of the intimation from the competent authority under Rule 4(3). So, my lord, we have paid the compensation. He has done the Panchanama.
The compensation, that is okay.
Right.
But the act says you have to do it in a particular manner.
Yes, that is correct, my. That is correct. But here is the case, my lord.
By that, King versus Nazir Ahmed,
Yes,
what you have to do,
if a particular thing has to be done, it has to be done in that manner.
has to be sent back. The court will consider it.
If, I beg to apologize, Your Lordship, if Lordship.
Oh, then I'll adjourn the matter. But this is something I dislike. He's on legs. You show disrespect to the senior counsel.
I beg your apologize.
Are we running away? Am I running away or Mr. Roy is running away?
Lordship, I beg to apologize, Your Lordship. I beg
Don't
to,
do it. This is something which is unpardonable.
Lordship.
You show disrespect not only to Mr. Roy, you show
I beg
disrespect to all members of the bar,
Lord.
to the court.
Lordship, I beg to
I
apologize.
have asked a question, he is responding to it.
Lordship,
Do you have a right to interfere?
Lordship, I beg to apologize, Lordship. I beg to
Next time
apologize.
you stand up, it will be adjourned for a long time.
Lordship, I beg to
Don't do
apologize.
it.
Lordship.
Senior counsel is responding to the court query and you are just interjecting.
Lordship. So my question is that, my lord, he has not filed application under section 10(2).
Second thing, always remember,
Lordship.
it's just the court of justice is just like a domicile sword. It can cut both ways. You won't even understand what will be hitting you.
Lordship.
Once you antagonize the court, then you disturb the proceedings. You won't even know what is coming. I am discussing because you want a law to be laid down. Otherwise, I don't have to tell you what I am doing.
Lordship.
I've told you because this is an issue which requires a determination. So we are telling you of your negatives and positives. The court is not bound to tell you what is going to pass. And that you know. But you won't even understand what will hit you. Yes, Mr. Roy.
So, my lord, he has to file in, first of all, where he went wrong, that he filed a money suit. The amount was not determined and he wants 8 crore something as per the Right to Fair Compensation Act. So he filed a money suit. He cannot file money suit, my lord, in my respectful submission. He has to file an application under section 10(2) and 10(5), my lord.
We're not disputing that.
Yes. Now thereafter, my lord, that section rule 5 will apply to their, my lord. And lordship, which is for my satisfaction, my lord, lordship will go to rule 4A also, my lord. How the compensation will be determined, that is given in rule 4A, my lord.
Just a moment. Which page is the plaint?
My lord,
Which page is the plaint?
claim, my lord, is page but his money suit, my lord.
Money suit, page 40.
18, 28. 40, my lord.
Dr. Amit, Dr. Gogoi, where is the order dated 9/2/2024? In money suit 7 of 2023, order dated 9/2/2024. This is referred at page 89.
You may see. That is at page 196, my lord.
And what is this money suit 7 of 2023?
Lordship, initially we had filed before the senior division of Gulaghat magistrate, civil just senior division. But as per the PMP Act, it must be go to the district judge also. Accordingly, after hearing both the parties, that trial court has referred to the district judge also.
Where is that order?
Lordship, get to page 195. Start from 196, Your Lordship. One 198 is the operative last part, my lord.
Yes, what did you want to say uh, when you interrupted Mr. Roy? What do you wanted to say?
Lordship, page 189. Page 189, Your Lordship. Lordship, got it. Deed is a deed of agreement for a sale. Same village, same place, same area. That
After taking
held-
compensation.
yes, that
After taking compensation.
yes.
This happens in all land use cases, don't worry. We have experience of that.
Oh, that's it. My relative, this person.
No,
has-
it's okay, whoever he may be,
uh,
but I also have that experience where you are standing. We have seen that.
Lords. That is my enabling effort to point
Okay.
out before this.
Take that. Heard Dr. B. N. Gogoi, learned counsel for the petitioner. Also, J. Roy, learned senior counsel assisted by Mr. Learned counsel for the respondent numbers 1 and 2, and Mr. K. K. Bhattacharya, learned government advocate appearing for respondent number 3, 4, and 5. Next product. In brief, the case of the petitioner is that he is the owner and possession, owner cum possessor of land measuring 4 bigha, 0 katha 7 racha, covered by periodic pata number 57 and dark number 56 and 104 of village Kanpala, Kanfalla, Chapuri, Chapuri, Gaon, under Rongamati, Rangamati, Moza, Kumtai, Humtai, in the district of Golaghat. The right of way in respect of a part of the land was acquired by the respondent number 1 company for laying down of underground pipeline for transportation of natural gas. Full stop. The provision for acquisition of the right of way is governed by the provisions of Petroleum and Minerals Pipeline Act from 1962 and rules framed thereunder. Next, please. The petitioner admits to the fact. Where is that payment which we referred to earlier, that 5 lakh something was paid?
599.
Which page is that?
Lordship, say, page 109.
No. I was reading that admission where the payment was made.
Yes, admission.
Which page is that?
Lordship may see 112, 112.
112. it would suffice to mention that as per the contents of the document annexed at page 112 of this application, the petitioner had received a sum of rupees 5,99,794 on 11/12/2021 in respect of land measuring 1 bigha 2 katha 9 lechas covered by PP number 104. No, sorry, PP number 57. Full stop. It's aggrieved by the amount of compensation paid not only the petitioner raised an objection before the Gauhati, but also made a prayer for reassessment of the compensation before the circle officer, revenue circle, Khumtai. Full stop. The other communications by the petitioner may not be referred, is not required to be referred in this order. Next, by to suffice to mention that dissatisfied with the amount of compensation paid, the petitioner had initially filed money suit number 7 of 2023 before the court of the learned civil judge within bracket senior division bracket was at Golaghat. You have a copy of that plaint here? Is the copy of that plaint available here?
Yes, ma'am. Yes, there, Your Lordship. I have annexed all the please.
No, where is that? Which page? The money suit 7 of 2023 plaint of that.
That is not annexed, right?
So as the copy of the plaint is not available, the nature of prayer made is not available. It would suffice to mention that the petitioner filed petition number 1713/23 purportedly under order 7 rule 10 of the CPC for return of the plaint, as the civil judge within bracket senior division bracket was at Golaghat did not have jurisdiction. To try the suit. Full stop. Accordingly, the learned civil judge within bracket senior division, Golaghat, by an order dated 9/2/2024, returned the plaint to the petitioner and refunded the ad valorem court fee for presentation of the plaint before a proper forum.
Lords.
Full stop. Next para. From the no, next para. It is projected that a fresh money suit number 1 of 2024 was filed before the Court of Additional District Judge, Golaghat. Full stop. The copy of the plaint is annexed to this application at pages 40 to 97. Sorry, 40 to 96. Stop. On a perusal of the plaint of money suit number 1 of 2024, which was been filed before the additional district judge, Golaghat, with comparative reading of the not comparative readings, let's track it the comparative reading. It cannot be said that the which page was that order? Allowing the plaint to be withdrawn? Where is that?
Your lordship is interim order.
No, the order by which plaint was allowed to be withdrawn.
Oh, that is 1 8.
The other learned members of the bar, we don't have time to take any other matter because there's a meeting scheduled at 4:30. Mr. Sheikh is, tell Mr. Sheikh. Mr. Sheikh. Mr. Sheikh will reach your matter tomorrow. Today we can't take it up. I'll have to rise in some time. You get your matter listed. What is your item number?
Item number 42.
42. 42. Other matters will be rolled over. We'll not be able to give it
42.
40,
42.
42. We'll get it listed tomorrow. Today we can't take it up. I'll have to rise now.
There is one thing, my lord, take it. The next item is my item number 50.
Those will be rolled over.
Second week of June anything.
After some time when I rise, ask a junior to tell the court pastor. All cases may not be accommodated, but yes, 2 to 5 cases you can accommodate. Which is the order?
196, madam.
196. It's not a case that the same plaint which was returned by the learned civil judge, senior division, within brackets, senior division at Golaghat, being money suit number 7 of 2023. Full stop. The case projected in the plaint is that There's a mention here, I am not finding it now, that the right to fair compensation. There's a statement here, right to fair compensation would apply. In the plaint file, there was a reference to right of compensation.
Yes, that he has made a statement,
We are now not finding it.
Lordship, I just,
Is it right to fair compensation would apply? And based on other stand taken in the said plaint, comma, the petitioner has prayed for a decree in respect of damages to crop amounting to rupees 88,12,800, compensation for land amounting to rupees 7,32,60,000 with interest at the rate of 15%, for decree of cost of litigation amounting to rupees 7 lakh, another miscellaneous expected.
para 30 is right to fair compensation,
Page,
page 59, last part, my lord.
right to fair compensation. Okay. Full stop. Next paragraph. Just comma. There is nothing on record to show that the change, the claim for money suit number 1 of 2024, which was filed before the Court of Additional District Judge, Golaghat, was an application within the meaning of section 10 within bracket 3 of the Petroleum and Minerals Pipeline Act from 1962, requiring determination of compensation by the district judge as provided for. The learned counsel for the petitioner to support his contention that section it may be further mentioned that along with the said plaint, the petitioner had also filed a separate application under section 5 of the Limitation Act for with a prayer for condoning the delay of 707 days beyond the period of limitation in presentation of the suit. The learned additional district judge, by an order dated 9/10/2024, rejected the said application for condoning of delay Next slide. In order to support the contention that the section 5 of the Limitation Act would be applicable, the learned counsel for the petitioner has cited the case of this is one and this is two. If you're citing any other case, please give it to the my court master. Give you a list and give it to the board. 1 and 2, we'll see to this. Next one. Has in the considered opinion of the court. Per contra, the learned senior counsel for the respondent numbers 1 and 2 submits that the suit would not be maintainable for compensation and adjudication, if any, could have been made only under, in excess of power under section 10 within bracket 3 of the Petroleum and Minerals Pipeline Act, 1963. It is further submitted that admittedly the petitioner has received the compensation amount without any protest, and the protest was lodged after the receipt of compensation. Accordingly, it is submitted that as the money has been received, received without initial protest, the suit itself was not maintainable. Next. In the considered opinion of the court, the suit which is presented in form of money suit number 1 of 2024 is a money suit simply cited and cannot be treated as an application for compensation within the meaning of section 10 within bracket 3 of the Petroleum and Minerals Pipeline Act, 1962. Request by virtue of which the district judge by virtue of which if the agreed person is not, the compensation amount is not agreeable to the concerned parties, the district judge would get jurisdiction on an application to determine the compensation. Under such circumstances, in a money suit simply cited, the provisions of section 5 of the limitation would have no application. The case of Mukri Gopalan, M-U-K-R-I, Gopalan within brackets relates to filing of an appeal under the applicable Rent Control Act, and therefore this is not a case where suit was filed with an application for condonation or delay. In the case of Omana Unjama, number 2, the paragraph 1 and 2 of the said decision projects that it was an application for determination of compensation filed under section 5 or rule 5 of the Petroleum and Minerals Pipelines within bracket acquisition of right of user in land bracket was rules cover 1963. So therefore, the applicability of the said judgment would only be in the case where the determination is made by the competent authority, which in this case would be the district judge. Next, therefore, the provision of section 5 of the Limitation Act cannot be made applicable in cases of simply cited suit for recovery of money. Next, therefore, as the suit cannot be equated with an application for determination of compensation, where compensation has envisaged in section 12 within bracket and 3 of the Petroleum and Minerals Pipeline Act from 1962. Our report finds no infirmity with the impugned order dated this is 9/10 or what is the date?
9/10/2000.
9/10/2024. Passed at page 257. It's circularized the meeting schedule. Before parting with the records, the court is inclined to observe that this order shall not preclude the petitioner to avail appropriate remedy, if so advised in accordance with law. I'm sorry, I have to rise. There's a order to be dictated which was incomplete yesterday. We'll make it CAV. Yes. But I'll not be able to do so.
In that case, we have submitted some citation.